All right. Good morning. I'm going to call the commission meeting to order. Regularly scheduled meeting Wednesday, June 14th at 10:14 in the morning. First item on the agenda is a discussion and determination of the commission's officers. Lawton Jordan, who is the chair currently of the commission, resigned effective May 12th, I believe, and has made the governor aware. He is the governor's appointee. So I'm vice chair and running this meeting at this time, but we do need to go ahead and elect new officers, or I guess vote in new officers. So are there any motions that I hear?
Yeah, I'll move that, based on certainly the tenure and experience of my other commissioners, that we move to elect Commissioner Adams as our new chair and Commissioner Kathy as our new vice chair.
I second that.
Okay, I've got a second and a motion. All in favor?
Aye.
All right, so the motion passes. All right, so has everybody had a opportunity at this time to review the minutes from our March 23rd meeting?
I did, if I could speak quickly on
Absolutely.
that. I found one issue that I think needed to be corrected.
Okay.
On page 5 of 6, the second case in the matter of Janie Reed. I believe the minutes may incorrectly reflect that I recused myself from that, and then that I made the motion. So I don't think that I recused myself from that. I think we might get that.
Okay, yep. So any other corrections that need to be made to those minutes?
Are the mics on? I believe.
Are they on?
I don't think they are.
Let me try this. Hello? Can you guys hear me better now? No? Says it's on.
Is the volume up or down?
Yeah. Good morning.
Good morning.
Is that better? Okay. And before we go back to the minutes, I would like to let the members of the public know. Is that okay? The members of the public know that I have asked for somebody from GBA to be called to get the air conditioning situation fixed. I think it's warm in here. I did just walk all the way over from the Pete Hackney deck and heels, but I do think it's warm, so we are getting that taken care of, so apologize for the warmth. Okay, so we had one correction to the minutes on page 5 of 6. Are there any other corrections to the minutes? Okay. Then I would like to move that the minutes be corrected, subject to the correction that was made by the commissioner, and with that correction, that they will be accepted. Do I have a second?
Second?
All in favor?
Aye.
Aye. Okay, now we need to move on to item number 4 of the agenda, which is the review of the OSHA decision in the matter of Carolyn Crosby. And let me get my stuff on there.
Madam Chair.
Yes, what number are you?
26.
Okay, go ahead.
Madam Chair, if I could, and I know you're still getting your stuff, begin by giving a brief outline of the statutes and our rule that governs consideration of OSHA decisions, and do so in my role as Executive Secretary. I'm not advocating for either party in doing that, but simply to provide the background of where we stand today after the OSHA initial decision was issued. So this case involves actually 6 cases that went in front of OSHA. Evidence was presented on 4 of those cases, and an initial decision was issued effective the 26th of April 2017, which is more than 30 days ago, finding that there were violations of the Campaign Finance Act and proposing sanctions that add up collectively to $30,000. The respondent in the case had a series of arguments regarding the validity of the law, primarily on constitutional grounds, which are grounds as an administrative body you cannot rule on, but can be ruled on by a superior court and otherwise, and as a Court of Appeals or Supreme Court, should be, depending on what the jurisdiction is in the case. In any regard, once a case has an initial decision from OSA, then by statute, and this is governed by OCGA 50-13-41C, the initial decision becomes a final decision within 30 days unless some action is taken on the initial decision by the Commission. The OSA group or statute provides that the Commission or agency can extend the period for consideration twice, 30-day periods each time, and does so with an order stating particular circumstances that allow it to be extended. And of course, I provided a copy of that statute to you. However, in 2008, the Commission adopted a regulation, which I've also provided a copy to you, which states that and this regulation is 189-2-.08, under Part 2A, initial decisions will become the final decision by operation of law unless Respondent or Attorney General's Office makes a written request for review by the Commission within 30 days of the filing of the initial decision. In pertinent part, that's what it states. So that doesn't call for an order or one that states with particularity the reasons for extending it. Then under OCGA 50-13-19, it specifically provides that the period for appeal of a challenge is 30 days after service of the final decision by the agency. So the question is whether, in fact, since more than 30 days have elapsed and an order has not been entered, whether in fact it is in fact a final decision by operation of law or not. Now I want to emphasize that both parties in this case, the Commission represented by Mr. Fuller and the respondents, there are multiple respondents, but the respondents who are represented by Mr. Humphreys, both wish to make oral argument and maybe present evidence, and that's of course up to you, on the merits of the initial decision. The date that they would like to do that is August 10th or in the first 2 weeks of August. I don't have any opinion on that, but I do want to draw your attention to all the various rules that govern the situation. You know, I think that given the complexity of the way the statute's drafted, our rule is drafted, and so forth, one could say that there is an open question here about the jurisdictional issue. And of course, I think it may be the case that the initial decision already is the final decision, regardless of what you wish to do. But I would also say that should you decide that you do wish to hear a oral argument on the initial decision, and the parties consent to that, I don't know that they can consent to extend jurisdiction, but nonetheless, they consent to that, that's within their purview. And you know, I can tell you from the Commission side, I don't think that we intend to raise a jurisdictional defect. We'd like the merits to be heard, but that's where we stand procedurally on this case.
So let me ask you some questions from a procedural standpoint. Make sure that I'm clear, and if any other commissioners have questions, feel free to jump in. And my understanding is that the decision of OSA was that Judge Howells signed that on April 26th.
Correct.
And so that would mean that the 30th day for review would be May 26th, correct?
That's correct.
Okay. And then but I have in our, or we have in our packets that there is a request for an extension filed May 17th.
Correct. Both the Attorney General's office and the respondent filed effectively requests that the commission reconsider the initial decision. I will tell you, without intending to speak for either party, that I think the Attorney General's position is that they wish to submit evidence as to victim impact. They don't challenge the underlying initial decision. Victim impact, if they want you to hear what the consequences are and perhaps increase the sanctions. And I believe that the respondents wish to address many aspects of the initial decision. But I think their arguments, and I'll let Mr. Humphreys speak for them, not me, but their arguments are largely that they believe it is unconstitutional.
Is there, I don't see anything in the statutory scheme, though, that by filing the motion requesting for the extension, that the order from Judge Howells does not become the final decision by operation of law on May 26th, since we did not do anything. Is that correct?
I agree with that, yes. That's what our regulation says, but I don't see the statute as saying that.
Okay, give me a second.
Does the statute address it at all?
I can only quote what the statute says. This is OCJ 50-13-41. And let me emphasize here that if you look at the administrative statutes regarding hearing of cases and so forth, they're complex. I'm sorry to offer this grace note, but let me tell you. What happened is that it used to be the case a long time ago that each agency heard cases themselves rather than having any independent body that heard them. So each agency had its own administrative hearing officers. In fact, this agency, for a very long time, continued to hear the cases themselves, even after OSA was created. They never had an administrative hearing officer. All the evidence was presented to the full commission. There were days of commission hearings where evidence was presented. And in your regard, OSA was created, and that's 50-13-41. So statutes that run from 50-13-13 up to 15-13-41 largely have been superseded by 50-13-41, except for 50-13-19, which is the appeal decision to Superior Court. Having said that, let me tell you what 50-13-41C says.
So what's the letter?
50-13-41 subpart C.
C.
Yes. It says that within 30 days after the close of record, or excuse me, I misspoke. It's D. Except as otherwise provided in this article, in all cases, every decision of an administrative law judge shall be treated as an initial decision. And then under E, a reviewing agency of 30 days to following the entry of the decision of the administrative law judge to reject or modify such decision. So you have a period of 30 days following the entry of the decision of the administrative law judge in which to reject or modify the decision. That seems very clear to me. If you look at subpart 2 of that, it says you may, prior to the expiration of the review period, extend such review period under unusual and compelling circumstances, entering an order that shall recite with particularity the circumstances, which has not happened in this case. Now, I want to emphasize that the reason it didn't happen in this case, well, there may be multiple reasons, but the primary reason is because, unfortunately, our chair, who would have issued this as a procedural order, resigned. And so there was no basis to have that really done without having a specially called meeting, which we had no chair to do. And then an additional period could be extended later in that subparagraph, that's E2. Bottom line being that it speaks in terms of an order stating with particularity to extend it, and in fact, no such order exists in this case.
Both parties do want us to have a hearing, though, correct?
That is my understanding. Of course, I'll let them speak for themselves, but that's my understanding.
That's what their motions say.
I think effectively that is the case. and I will say that neither party has at this time filed an extensive brief on the merits, but I would suspect that if oral argument were held, they probably want to brief the commission on the merits. They've both filed very short pleadings, basically to seek an extension or to challenge the rule.
I'm just wondering.
What's your mic?
24, sorry. I'm just wondering at this point if it would be appropriate to, have Mr. Fuller and counsel for Ms. Crosby to state what their position would be in this regard, just so that we can hear what they have to say.
Yeah, I'm fine with that. I think if Mr. Fuller and Ms. Crosby's counsel will do that. I will caution you though, you do need to keep it with respect to the law, with respect to whether we have the ability to actually hear your appeal, in essence, at this time, and whether if by operation of law, Judge Howell's order went into effect. If you go beyond that, I think we're going to have to stop you. So I'll start with Mr. Fuller. What's your mic number?
Number 16.
Thank you, Madam Chair. In sum, just I guess from a procedural standpoint, the reason for the request mostly was to create a record that we can address on petition for judicial review on the when we take it up on appeal. Because I believe I don't want to speak for Ms. Cosby's counsel, but I think that was the intention all along, is to just create a record that can be taken up on appeal. Not addressing the merits here, but in dealing in administrative law generally, when you get to the petition for judicial review stage, the Superior Court is confined to only reviewing the record that was before the agency. And so there have been times before that our office, on procedural grounds, when we get to Superior Court and opposing counsel is raising new issues for the first time, as a procedural bar, we can say that was not presented in front of the commission, and therefore they can't address it now. And procedurally, we prevail in that regard.
But Mr. Fuller, my understanding is also that we are limited at this point as to what you all put before Judge Howell's. So I don't think any new evidence could come forward in any hearing that we would have. Am I correct?
Respectfully, I would disagree to some extent. I think the board does sit as both an appellate, and to piggyback on what Mr. Ritter was saying initially, the reason for the hearings at OSA is to sit in place of the board as the fact finder, but ultimately the board is the one that makes determinations both as to findings and violations of the Campaign Finance Act before it goes on appeal. I think as an intermediate step, OSA serves as a more efficient way, since they have a system in place with judges and that sort of thing, for both parties to present evidence and not take up the time of the board. But in the traditional sense, the board does sit as the ultimate fact finder. And there, in other, I'll say with other agencies, the board can deviate from the findings of OSA if the board so chooses to. And but as well, the board can consider other information that's, I would say, relevant to the initial decision in making its final agency decision. So with respect to being confined necessarily to what was presented at OSA, I would respectfully say that the board can consider new information if they so choose to, because ultimately the board is the one that makes the final agency decision that will go up on review. But to get to the point about procedurally whether the board can even hear a final agency review as requested, I think per my reading of the code as well in 5013-41E, as Mr. Ritter has articulated, because no action has occurred on that initial decision, even though both parties have requested a hearing, which doesn't necessarily prevent it becoming final by operation of law, I do believe that because the 30 days have lapsed, that the Judge Howell's decision by operation of law did become final.
So it's your position that that Judge Howell's order by operation of law is already final and was on May 26th?
That's correct, without any action on behalf of the commission, either extending it or denying the motions, or just no action by operation of law becomes final.
Okay, thank you. And Ms. Crosby's counsel?
Yeah, I'm Stephen Evers.
If you'll go ahead and come to the table right here, please.
Thank you. I'm Stephen Humphreys, representing this capacity. And frankly, we are completely blindsided by a number of issues in this. We've had very good cooperation with the Attorney General's office, and Mr. Fuller has been excellent to work with. But this is the first time we've heard his opinion that this is a final agency decision. We've been working in cooperation to have this extended. We both filed our motions to seek reconsideration of the OSA finding, and we agreed on that we both want to contest it. We filed that motion timely according to the regulation that Mr. Ritter cited. We have no awareness or control over whether the commission has a chairman who can, call this body to action to, act on that or not. So that's, an issue that's completely out of our control, and frankly, I'd argue, raises a notice issue for us. We would like to argue that decision. We would like to present some evidence. I understand Mr. Fuller would like to, but I think that we would also be prepared to argue it on the evidence that's already presented to OSA, which I think supports our position. But we also, are, concerned is to have that, fully argued and a record fully developed in case that it goes up to the Superior Court, that we have some, basis to argue the record. As everyone has pointed out, that's the only matter that the Superior Court will be able to consider. So that's why we're asking that, and we were not aware of the problems, to follow that procedure that we contemplated with the Attorney General.
I'm 22. The hearing at OSA was an adversarial hearing with both parties present, represented by counsel, and we had an opportunity to put evidence up at that time, correct?
That's correct.
All right. There is a record.
Yes, sir.
There exists a record that you say you're willing to argue that.
Well, if that's what we're left with, I mean, both parties, I think, would want to present some evidence.
Yeah, I understand that, but isn't your position, well, I don't want to confine it, but one of the positions you have is that the operation of the act was unconstitutional, at least for your client, is that right?
That's correct.
As applied.
That's correct.
And that error is there and is preserved, correct?
We have raised that argument,
All right.
yes.
And your time to appeal that to the Superior Court, it has not expired, correct? By any stretch?
Well, I haven't done the I'm not, if we're saying that which is a new contention to us, that decision became final on May 26th. I guess we do have a few days to.
I think the board acknowledges, especially what Mr. Ritter said, that there is some, if not conflict, some confusion about certain things. Mr. Fuller, do you have a position on whether the appeal is still right?
I do believe the appeal is still right because of the 30-day window that comes after the decision becomes final about operation of law.
And the question that I pose to somebody who might know is, if we simply move today that the opinion is final, does that create a new date from the tolling installments? What's your position on that?
Well, we would certainly prefer that to finding out on June 14th, that we have until,
11
next
days
week,
to-
and I'm supposed to be in Moscow next week, and that we have to, file an
Are you
appeal.
colluding with anybody?
I'm an anti-colluder.
Does, and Mr. Fuller, what's your position on that? If we had a motion today that we conclude, or we move, or we find that the appeal, that the decision from OSU is final, does that create 30 days from the day for the appeal to the?
I don't believe it does.
Mr. Ritter, do you have any opinion one way or the other?
I can tell you is that I think that, I'm going to be quite frank, if I were in Mr. Humphrey's shoes, I would probably seek to have the, whatever they're going to file in Superior Court, filed by the 25th of June. And this is why. Because the statutes are not crystal clear on it. It says 30 days from service, but the reality is that there isn't often service of a final decision because it becomes final by operation of law. So the service of the initial decision is typically the case, and I can tell you that the courts have found an absence of jurisdiction when it's 60 days from the date of the initial decision. And so I think the safe thing to do is to say the 25th of June. You could argue we didn't get service of it as a final decision until we sent it to you today, but I think that runs your own risk, Mr. Humphreys.
My fear is that we can do that and it'd be meaningless. The 30 days would be construed by the court that it expires in June, no matter what we do, unless we open it up for a long hearing. And you may be relegated to one of those positions where you have to file skeleton appeal and do your amendment, things of that nature. But it is not a de novo hearing, is it? It's just on the record.
That's my understanding, is on the,
You don't have to admit that, or you can say, I don't know, or maybe a court.
I wasn't looking ahead that far. I thought we had a routine
Maybe-
setting of a hearing for August 10th, is what
Maybe
I
you could
was
get
expecting. We were going to talk
Maybe y'all
about
could
it.
get leave of the Superior Court for that evidence in at that stage. I thought they would do it. And they may not be able to, maybe jurisdictional. But you've answered my question. I think you're bothered. What's bothersome thing to you is you got a very short window to appeal if this thing became right on the 26th of May.
Well, we have a short window and really, a lack of notice all along that, honestly, I wasn't prepared to come here, this morning and
And
address
I can
this
appreciate
issue at
that.
all.
My problem is I don't know whether there's anything we could do that would expand your time, because maybe running by operational law. But that's thanks for the responses from both.
Thank you.
Madam Chair, I just want to say, just also for the record, I understand, the position that you're in, and then certainly what you're telling us this morning, but, again, I'm looking at the statute, and I'm not sure that we certainly have the ability to change, what is set forth in the statute. I'm just looking at, E1, and it says that, we've got 30 days following entry of the decision in which to reject or modify that decision. It does have this, subpart 2 that talks about, this extending that time under certain orders, but in the absence of that, I'm not sure that if we didn't have, if we went forward and had some hearing, in August, I'm not sure that any of that would, as the appeal progressed, change the fact that the initial decision actually became final before we ever even opened it up and had that hearing. And so, considering everything that we've heard, unless someone else has got anything that they want to add at this point, I think I would move for the commission just basically to recognize that the decision became final 30 days after the issue was made, and that we take no further action on it at this point.
I'll second that. Do we have any discussion?
No, this is Jake Evans. It's good to meet you.
What is your mic number?
19. I mean, I would have to agree as well. I mean, just reading the plain language, I mean, within 30, if you felt that the agency fails to do so within 30 days, the initial decision becomes the agency's final decision. We can't extend it. We haven't extended it. So I think that I would have to voice my opinion and approval of his comments.
Any further discussion?
Well, if I could just add one thing, and I'm just, I'm kind of thinking off the top of my head, and I don't know how this will operate, but if the fact that both of us basically filed for the extension and that decision was pending, and it was filed before the 30 days expired, I don't know if there's any argument that extends the 30 days until the commission actually decides. And it sounds like, everyone's hands was tied, and, we weren't able to do anything about it, the commission wasn't able to do anything about it. And it seems like, run into that, there are situations, in other legal proceedings where if, a motion is pending, then that finality of the decision is stayed until that motion is actually decided.
Which is why I asked the question initially, if that motion did toll the running, and it doesn't appear that the statutory scheme contemplates that. And
I'm sure the legislature didn't contemplate any of this that we're, dealing with today.
So
Which in some cases, I know clerk for a federal judge, we had to fill in where the legislature didn't consider the situation.
at this time, we do have a motion on the table and a second. Is there any further discussion before we take a vote?
Yeah, I would like to just, could I hear the motion again?
I'll do the best I can.
Give me the cliff notes.
Sure. I'm going to move for a recognition by the commission that the decision became final 30 days after the issuance date, which I believe is 4/26, and that there will be no further action by the commission on that decision at this time, including scheduling a hearing and all.
And I would like to add to the motion saying that by operation of law and by the statute, it became final.
Yeah, because technically I wouldn't say any action needs to be taken on behalf of the commission if it was done by operation of law. I mean, I guess we can voice an opinion that it is final, but outside of that.
That's correct. That was why I used the terminology a
Recognition.
recognition, as opposed to us actually taking any action. Because I agree, I think by the statute it became final by operation of law, certainly by not any action that we're taking today.
That's right. So the vote today would be purely that we recognize that the order of Judge Howells on this matter became final on April 26th. So,
What?
Yeah,
Is it April 26th or May 26th?
sorry, May 26th.
What was it that Chairman Jordan was asked to do that he couldn't do because he wasn't here? He wasn't chair. What exactly was our chairperson asked to do?
Here's where our chair discussions occurred, and I normally don't publicly share those, but let me tell you.
Well, it was mentioned it publicly here.
Yeah, I know, and I mentioned it. Let me address exactly what it is. I think that a procedural order could have been entered in this case, granting the motions to consider the initial decision, and that would have been done by the chair. Or the chair could have called a special meeting to consider it in front of the full commission. Either could have been done. But, and I will say that Mr. Jordan and I began discussions on that, and he told me that he resigned. So we didn't really get into the meat of that. And then I went back to him and said, what's the date of your resignation? And I think the vice chair could back that up. And he said, no, because I hadn't gotten a letter. I just gotten verbally on that. And then I saw a letter later that went back to that prior date. So it went before I even realized it. Yeah.
And as Mr. Hopkins pointed out, he had no knowledge of any of that, correct?
No.
I think the issue here is whether we do something that makes it, I think I don't hear any support for opening this up to other evidence. So I think the only thing you could net out of this is changing the date of the official time the order is the order. But I think that's all that I'm hearing. Doesn't seem to be enthusiasm for any more evidence. But the AG wants to put in evidence that would pile on more penalty to the clients. Complete law started.
Well, I won't get into the substance of fighting that off, but.
All right, so we have a motion on the table in a second. So at this time, seeing no further, yes?
I'm sorry, Madam Chair, but I just want to contribute a thought. Is part of the motion, the concept then that the motions that were filed are denied as moot?
I don't think that was part of the motion, because the motion is purely just a recognition that by operation of law, the order of Judge Howells became final on May 26th.
But I also think by the same operation of law, those do become moot. I'm not sure that that even requires any official action.
I understand. I
That's
just want to make
correct.
sure that we're clear on the record.
When were they filed?
May 17th.
The one was filed May 17th and one was filed at the very last day that it could have been considered.
All right, so let's call for a vote. All in favor? Aye. All opposed? Okay, motion carries. Thank you. Move on to item number 5, preliminary hearings. Before we get into preliminary hearings, that took a bit. Let's take a 3-minute biology break, please. And we're going to start with the preliminary hearings, which is item number 5 on the agenda. I understand that items C, F, and G have been moved down to agenda item number 8. Any other agenda items that need to be moved?
The only other one, Madam Chair, would be item D, but I think that's been called by consent order, and since I'm already up here, I'm happy to take it in turn.
No, if it needs to be moved down to the consent order.
That's fine. That's the only one that needs to be moved.
Okay. All right, so then we only have items A, B, and E. Is that correct?
Correct.
Yes, ma'am.
Okay, all right. Let's get started on 5A, please.
Yes, ma'am. Commissioners, what you have before you is the preliminary hearing in the case of J. Wayne Gardner. It's case number 2009-0045. In this case, Mr. Garner was the mayor of the city of Carrollton from 2009 until 2014. Mr. Garner's action arose when he received a complaint from the original complainant. And the complainant alleged that Mr. Garner had a number of violations, those being specifically that he failed to file his personal financial disclosure statements on time, and that he failed to disclose a number of items on those financial disclosure statements. Just by way of background information for y'all, although Mr. Garner was an incumbent of the mayor in position as mayor of Carrollton, Georgia, he did file a declaration of intention to accept campaign contributions on March 28, 2011. From the best that we can tell, he filed one previously with the city of Carrollton, but given the span of time that's elapsed, they have destroyed those records in keeping with the statute's retention schedule. So we don't think they did anything wrong, we just can't verify that he had a DOI prior to 2011, but the other circumstantial evidence leads us to believe that he did. Mr. Garner qualified to stand for re-election on August 29, 2011. And the last personal financial disclosure statement that he filed was filed on, September 13th, 2011, and again on July 7th, 2012. There is a little bit of a lag time between that financial disclosure statement and the deadline, and I'll circle back to that in just a moment. In addition to looking at the timely filed, we noticed that Mr. Garner left off some key information. He had fiduciary or business interest in 4 companies, those being the Garner Group Incorporated, where he was a fiduciary and also held an investment stake, First Family Funeral Incorporated, where he was a fiduciary and owner and also held an investment stake, Southeastern Resource Incorporated, where he was a fiduciary, and he also had an ownership and investment stake, and Azimuth Consulting. On all of those, Mr. Garner failed to list those issues on his, or those specific items on his 2009 personal financial disclosure statement. That leads to 14 independent allegations that remain outstanding. And I'm not going to bore you all with the code sections, but we are alleging that he violated sections 21550A1, which is the failure to timely file and the failure to file at all. We allege that he violated 21550B2, which is the failure to disclose the fiduciary positions held by a public officer on his personal financial disclosure statement for 2009. We're alleging that he violated 21550B3, and that's the failure to disclose investment interest. That he violated 21550B4B, that's the failure to disclose real estate interest. And that he violated 21550B7, and that's the failure to disclose the wife's ownership interest in a number of businesses as well. And for a quick summary, we noticed that his campaign contribution disclosure reports, they were substantially compliant as considered by the Campaign Finance Act under section 215.7.1, as well as further enumerated in our rules and regs at 189-2-.01 subsection 20. However, the financial disclosure statements, as you can see, his calendar year 2011 and 2012 forms were not filed at all, and they're still outstanding. Now, the calendar year 2010 is the one that was filed from our records a year late on July 7th, 2012. But as y'all recall, during that period of time is when the computer system was not entirely trustworthy. So we gave him credit for it being timely filed. And that's one reason you're only seeing 2 allegations for the failure to timely file. And then the remaining 12 allegations stem to the 2009 PFDS, which we have listed for you on the PowerPoint slide. I'm not going to bore you with them. But it just lists the sections of the personal financial disclosure statement that he failed to fill out related to the 4 organizations, that being the Garner Group, First Family Funeral, Southeastern Resource, and Azimuth Consulting. Also, by way of full disclosure, Mr. Garner has been representing himself in this matter until yesterday. I received a phone call from an attorney by the name of R.K. Perry, who made intimations that he would be representing Mr. Garner. No official notice, no official entry was filed, but I did receive an email at 5:08 p.m. yesterday telling me that his client had agreed to the consent order that we had mailed him many months ago. That's the last communication I received. That email said, I can't send you a copy of the signed consent order because I can't work the fancy fax machine at my office and my assistant has left. There was nothing this morning, and I checked, and there was nothing as of a few minutes ago.
Is Mr. Garner here?
No, ma'am.
All right, so
And neither is
Mr. Harriet.
Mr. Perry is not here either. What I would ask for the commission is our proposed resolution is that the commission go ahead and find reasonable grounds to believe that a violation of the act has occurred, and that will still give Mr. Garner and his counsel, if it is in fact Mr. Perry, 30 days to go ahead and adopt that consent order and send it to us if that's still their desired goal. But this way, this is a case from our prior hearing where we had trouble finding Mr. Garner for a period of time. We finally found him, so this way we can still move forward and they still have their opportunity to settle if they want.
And service was perfected, correct?
Yes, ma'am. I actually have the return of service from our process server that served over under the Gold Dome on the last day of session.
All right, I'll move that we find reasonable grounds to believe that there's been a violation of the Campaign Finance Act by Mr. Garner. Do I have a second?
I'll second.
Any discussion?
Mr. Lane?
Yes, sir.
What is your philosophy on leaving open this proffer, this consent order?
If they are speaking of the one and only consent order we made to the offer and settlement and compromise, if they want to accept it, it's open. Even if they want to modify the terms slightly, I'm happy to discuss that with them. In fact, by operation of law, once y'all find reasonable grounds to believe, there's a 30-day period at which they still have the ability to negotiate before it's ever referred to the Attorney General's office. And
I'm wondering, it's almost like there was an offer and an acceptance, even though it's an unusual way.
it is. I think my concern is the last-minute entry by the attorney and not having an official entry.
Okay.
And we followed up with Mr. Perry a few times before this because we had heard rumblings from Mr. Garner that he was the counsel. And we never, over a period of a month, we never heard from him until yesterday.
And Mr. Ritter, do you?
Yeah, that's a matter of policy, and I want to say something about it, just so that we're crystal clear. We offer consent orders to folks. Sometimes they ignore them or they just don't get around to it. It comes up and it comes in front of you. But once you found reasonable grounds to believe that is what we would call probable cause to go forward, we certainly have what we think would probably be a stronger case. I think that the fact that it goes to a hearing means that the offer actually technically is not on the table anymore. They want to make the offer back to us, we very well might accept it. But I don't want anybody to be misled in saying, well, I can accept a consent order if they found reasonable grounds, because we would consider a new case, a new matter at that time.
That was my concern.
My question would be, what are your considerations in continuing this? Given the fact you've emailed him, he said, we accept it. He admittedly hasn't gotten it to you, but what are the considerations for continuing to the next meeting and hearing it today and getting the reasonable grounds?
Given the prior dealings with Mr. Garner and the lack of his counsel's communication, I'm hesitant to give them further bites at the apple because, as I'm sure y'all may recall at the last meeting, Mr. Garner had knowledge of his previous hearings because we served him at the registered address he uses as a lobbyist with us. So he got his lobbyist badge. He got all of his late fee notices as a lobbyist. But he was always ducking service as to this complaint. So we finally served him by a process server at quite an expensive rate for us because it was the last day of session and the gentleman had to do a stakeout. So that's my concern with kicking it farther down the road. He still has the opportunity to negotiate. I understand Commissioner Cathy's concern of allowing people just to accept an offer even though y'all have found reasonable grounds. The only reason I would be happy taking this is because it's a fairly stiff fine. And it's near the maximum of what I would do to him anyway, so if he wants to take it, I'm not going to argue against myself. I don't know if that answers your question sufficiently.
I mean, the only thing this does, as I understand it, is just, it's going to limit him down to 30 days. He's going to have to accept the consent order within 30 days or we're going to proceed on.
Exactly.
Yeah.
Okay, any further discussion? All right. All in favor then of the motion to find reasonable grounds that Mr. Garner has violated the Campaign Finance Act? All in favor? Aye. Any opposed? Okay, thank you. All right, let's move forward. I now have the matter of Neil Craig Pruitt.
Commissioners, in the matter of Neil Craig Pruitt, that's case number 2010-0053.
Is Mr. Pruitt here?
No, ma'am.
Does he have counsel?
No, ma'am.
Okay.
This is the case that also came before you last hearing, in which he did have counsel, and we served notice on that counsel. And as soon as they received notice, they filed a notice of withdrawal with the commission, notifying us that their client had become uncommunicative with them for the period of the past year, and they had no idea where he was currently located. We have subsequently tried to serve him via process server at his 3 residences in Metro Atlanta, and we've tried a number of times. I believe the total has been about 4 times. We have been able to confirm that Mr. Pruitt is receiving mail at those residences, but we have located an additional residence that appears to be an inheritance that was recently probated in Newton County. And we actually have the process server in the Sheriff's Department in Newton County trying to track him down. By way of a status update, which is basically what this case has become given the inability to serve him. Mr. Pruitt was a District 3 State Senate candidate back in 2010, and after auditing all of his filings, the only violation he has, once you dispose of the rather specious allegations in the complaint, is he has a late fee of $125. To be quite frank with the Commission, if service fails this most recent time, the next 2 attempts, I believe this is going to come back before y'all in September with a motion to dismiss. Because at this point, we've already spent the better part of $800, and it's to collect a $125 late fee.
So it's just being tabled?
It's been tabled and giving all status updates since it has appeared before you. We just wanted to make sure you were aware. We weren't just putting it off in the corner. We are trying to find him.
Okay, thank you. All right, so now I have E, in the matter of Clinton Dean Young.
Yes, ma'am. And
Okay, is Mr. Young here?
no, ma'am.
Or his counsel?
No, he is pro se.
Okay,
Mr. Young's case is 2015-0051 PC. Mr. Young was the post 2 alderman at large for the city of Savannah. Mr. Young, also by way of background, has an older case with the commission. The case actually stems from 2009 when Mr. Young first assumed the post of the post 2 alderman in Savannah. One of the issues that we have is that Mr. Young began taking substantial amounts of campaign contributions prior to the filing of his declaration of intent to accept campaign contributions. That is his largest violation. He filed the DOI on November 4th, 2011. All of his campaign contributions, of course, were before the election date, and so were the expenditures. He qualified for re-election on September 1, 2011, and he had a lot of issues with filing timely or just filing at all. In fact, he had the exact same violations he had in the first case, which the commission disposed of back in 2010. Very briefly, we allege that he impermissibly accepted $1,710 in campaign contributions prior to the filing of his DOI. That's a violation of Section 21530G of the Campaign Finance Act. He failed to file his CCDRs for September 2011 and October 25. That's a violation of Section 21534C2. He failed to file his CCDRs for December 31st, 2011, June 30th, 2012, and December 31, 2012. That's a violation of 21534C1. So basically, it's the non-election year schedule because he did have money left over. He failed to file his PFDS timely for calendar year 2010. And then the second severe allegation, aside from taking money too early, is that he failed to disclose over $3,000 in campaign expenditures for ordinary necessary expenses on his disclosures. We were able to verify that they were actually ordinary and necessary expenses, so he was not pocketing the cash. He just didn't disclose it. They were basically for campaign signs and other electioneering items. Before you on the screen, you actually have a summary of those contributions as well as the expenditures that were not shown. We are asking the commission to find that there are reasonable grounds to believe that a violation of the Campaign Finance Act occurred. And much like Mr. Garner, Mr. Young called yesterday and said that he was interested in accepting a consent order. We talked about the terms of the consent order. It was sent to him. We've not heard back from him on whether it will be accepted or not, but we're happy to continue negotiating with him for that period of 30 days before we refer it. Just by way of, for the commission's understanding, in that proposed resolution, Mr. Young would have to reaffirm the debt he owes to the commission in that older 2009 case, which is part of the collections, which you'll receive updates later in this hearing. But he would have to reaffirm that debt and continue payments on that. So it's kind of rolling two cases into one.
Is that actually reflected in the consent order?
It is, in the proposed consent order that has been sent to him. And he understands it. He would make arrangements to do it. The consent order, if it eventually does come before the commission, it is lenient in its repayment terms, simply given the information we have been able to glean. Mr. Young, about the time he left office, his wife passed away while delivering their child. There were complications from that birth, leaving the child as disabled, actually fairly profoundly disabled. So he is a single parent of a special needs child. So we would give him consideration in the repayment terms of that to make sure it is something that he can handle and not set him up for failure. So we are working diligently with him. He's just unfortunately waited a little too late to get the ball rolling. But he has been communicative other than that.
Okay, I'll make a motion that we find that there are reasonable grounds to believe that Mr. Young violated the Campaign Finance Act. Do I have a second?
A second.
Okay. Any discussion? All right, all in favor? Aye. All opposed? Okay, so that's it for the preliminary hearings as I have it revised at this point. Let's go ahead and get this motion to dismiss done, and then I think it would, before we go to lunch, we can move item number 9 up to prior to lunch unless anybody else has a problem with that, or, okay? All right, so let's do item number 6 and then item number 9 and go from there. So Ms. Wetzel.
Commissioners, this is a motion to dismiss in case number 2012-0058 in the matter of Bill Heath. On behalf of, is Mr. Heath here? Mr. Heath is not here, but Mr. Belafonte is representing this, Senator Heath, rather, excuse me. This motion comes before you based on a case that was filed in August of 2012. During 2012, many Republican senators faced primary opposition, and the Senate leadership decided to use funds that they had to create an independent committee to help protect incumbents in the primary, because generally state parties do not participate in primary elections as far as promoting. Just at the outset, I want to note that this case is a companion case to a case that you dismissed at the last meeting, 2012-0048 in the matter of Chip Rogers. So it's the motion's basically identical, and that was passed at the last meeting. Basically, the complainant alleged that Senator Heath accepted contributions from the PAC that was created to promote the protection of incumbent senators that exceeded campaign contribution limits. But during the investigation, it was concluded by staff that the expenditures were in fact independent and were not, and are therefore not considered contributions to the candidate. And this comes before you because it was not a good fit to be an administrative dismissal, because there is some evidence that could be weighed towards showing that they could be contributions, but it was the conclusion of staff that the weight of the evidence weighed towards that these were not contributions and were in fact independent expenditures that were made independently of Senator Heath's campaign. And for those reasons, I've asked that the complaint be dismissed. All right, Mr. Belafonte.
Good morning, Madam Chair, members of the Commission. I actually have nothing to add today. I think the presentation has been superb, and I will take my seat unless there's any questions.
Smart fellow.
He sat on this side before.
That's right.
Okay, then I'll make a motion to accept the motion to dismiss and grant it.
I second that.
All right, any discussion? All right, all in favor? Aye. Any opposed? Okay, all right, thank you. Okay, let's move on to agenda item 9, which is the proposed new rule of the commission.
Thank you, Madam Chair. I'm going to step up to the podium because I think it's clearer if I speak from the podium, and also courtesy since both sides will be speaking from here. Today, we'll get to the proposed administrative or advisory opinions later, but we do have a regulation as well that we have proposed, which would be new regulation 189-7-.03. Unusually, this regulation has drawn considerable opposition from the Georgia Municipal Association and some of its members. And I will speak about that in a moment, but first let me touch on the regulation and the basis for the regulation. The regulation would require at the end of each month the local filing officers to send electronically some sort of report or statement to the commission saying these are the people who have not filed with us but had an obligation to file with us. Frankly, we would be delighted to receive an email that says there is nobody on that list, or the report we sent you last month has not changed. And I don't know what we will receive from local filing officers, but it is important that we understand very briefly the landscape under which we propose this regulation. In 2013, the General Assembly considered effective January 1st, 2014 statutory changes so that in the past, all filing for all different types of candidates and elected officials was done directly with the Commission. The Commission is the repository of the records and its responsibilities under statute to produce those records to the public. At the request of the Georgia Municipal Association and others, but primarily it was GMA, that was changed so that filing for local candidates and elected officials was now done with their local election official. At the county level, that's an election superintendent. At the city level, that is a city clerk unless the city has an MOU with the county. So I can tell you that having spoken to city and county election officials, most recently about a month ago, they're meeting in Savannah, there is an extraordinary opposition to this, particularly at the county level, because the records are still required to be sent to us, which is great, and we have the duty to enforce the law. So if someone is late or does not file at all, we have the duty to send them notice that they're late and then to try to collect the fees as to their lateness. In fact, what we had learned through the audit report that was done on the commission at the request of this commission was that the failure of the commission in the past to collect those late fees was a serious problem. After I became executive secretary, we looked at this problem closely and found that there are in fact millions of dollars in the past that have been uncollected. And that's just from people we had data on. The fact of the matter is, as to local level filers, we often do not know who has an obligation to file with us. Why don't we know that? We don't know that because we cannot make a complete list of who is required to file locally. That's because, of course, the elections are held locally. There are often people who resign, are appointed, who fall into some other category where they would have a filing obligation, but we are never told. Declarations of intent to run for office are made locally, and they're supposed to be transmitted to us, but they may not be transmitted to us. And that is often, in fact, the case. And I can tell you, even the biggest counties, we have frequently gone back and said, is there a declaration of intent? We've even had that with Fulton County with the mayor's race, where we've had complaints against people running for mayor. We said, well, we don't have a declaration of intent they're running for mayor. Well, they filed it locally, and Fulton County had yet to transmit it. So we don't know who all the candidates or officials are who would be filing those reports. Nor do we know who's actually filed locally. There is an obligation under the law for the local clerks to send those to us by e-filing or e-fax within 30 days. And indeed, we would pursue it against the local clerks if we knew that they had materials to transmit to us but did not. We are trying to gather that information, but the fact of the matter is we have two negatives. They wouldn't have transmitted it because they had nobody, and they haven't told us they don't have anybody. So we can't know who that is. Ideally, we would know who everybody's supposed to file, we could see who hasn't filed, and then we could pursue those folks, but that's not possible. That is not possible, not only practically in the real world, it is not theoretically possible for us to know that. Now, we asked for an opinion from the Attorney General a couple years ago and received an opinion back from them, and it covers a number of different grounds on late fee issues. For instance, many locals were believing that they not only could collect the late fees themselves or waive them, and they were often telling their local elected officials, well, you're late, but we're just going to waive the lateness, and we're not going to collect a fee for that. Or they'd collect a fee and they'd keep it themselves. And the Attorney General said, no, you can't do that. There was, in fact, advice from GMA saying they should keep the money themselves. That's not the law. But anyway, the opinion of the Attorney General's office does say that once a local authority decides that a report is late and establishes the amount of the statutory late fee due, the Act gives no further power to that local authority in the actual collection of the fee. And a key phrase for us today in that is that once the local authority decides that a report is late. So they're making this lateness determination. I think it's driven by statute as to the time frames. Nonetheless, they have to tell us that they have made such a determination. I would suggest to you very clearly, local filing officers are not filers with us. There's no filing requirement to us. They serve as our agents. What they do under this agency relationship is receive the filing on behalf of the state, which is the repository of the commission, and then send it to the commission, which keeps the filing. So they receive it, send copy to us by e-filing or e-fax. I won't get into the e-filing or e-fax methodology, though I think we're all aware that that is a very inadequate methodology, but regardless, they are required to send it to us, and we are supposed to be the repository, so they function as our agent in receiving the filing. So we want to simplify and make this process crystal clear for everybody. And that's why we propose this regulation to tell us who hasn't filed. You know who's not filed. You have the obligation to determine who is late. Tell us who you've determined is late. Frankly, I don't care what format that lateness notice comes in. If they've got nobody to add to the list, no big deal. This is not them filing CCDRs, the Campaign Contribution Disclosure Reports, or PFDS, the Personal Financial Disclosure Statements, with us. That's not what this is. They're not filing those reports. This is them just telling us who's not filed with you, who's late. I'm not asking for additional information on any of the reports that are required by law. And I think that, you know, this is obviously the best way in terms of directness to do it. But there is an objection that has been made by this by GMA, and I want to briefly address that, and then let them have a comment on that as they may, and other folks. And that,
Mr. Ritter, one second there.
Yes,
Before
ma'am.
you go into GMA's comment, let me just make sure that the commission is clear that, and the public is clear, what the rule is that is being proposed is asking the local filing officers to just tell us who's late in their filing.
correct.
Not to send us the CCDRs or the PFDSs at any other time other than what they already are required to send them to us by, correct?
That is absolutely correct.
All right, and then the next question I want to make sure we're clarified on is that the rule is not asking the local filers to determine the amount of late fee, correct?
Correct. We're not asking for that. I think that can be statutorily determined. But let me elaborate on that.
Correct.
Although we do not ask for that in this rule, I will say the Attorney General's office does imply that they could make that determination. And I think the implication from that is then they have to tell us if they have. And I did not mention.
One more question there. The collection of any late fee would be, that burden then would fall on the AG's office, correct?
No.
Or on us?
It falls on us.
Okay.
It falls on us.
Because we would have to then open a case against the local who is late, correct?
Well, correct. We would open a matter on it and send them notice. It would not rise to the level of what we would call an investigatory case because this is a fee, so it's by operation of law rather than by finding of the commission itself.
Okay, all right, that clarifies that for me. Anybody
Right.
else have any other questions before he moves forward on?
Right. Well, I might add, you've reminded me of one thing, and I might add to this, the issue about the amount of the fees. It is in fact still the case that some local jurisdictions are receiving fees and keeping them locally. And I only know this through anecdotal evidence when they happen to just mention it, but we don't know whether someone is paid a fee or not. We cannot be sending out notices to folks who are not actually late. We don't want to be in that business. Nor do we want to be telling them that they owe money when they in fact do not owe money. We look foolish when we do that. However, we do want to start complying fully and appropriately with our responsibilities. We're not actually trying to dump on the locals to do something. We're trying to take that responsibility that we are supposed to be handling, but we need the basic information to do it. And that's all we want. Let me go to their objection. I think that they have pointed something out that I was surprised they pointed out, but I do want to make sure that we do address it. As you may know, for a long time, the Commission had no regulatory authority at all. That was changed, and there was a subsection added, 2156A7. I won't quote the entire thing, but it says that you have the authority to adopt rules and regulations necessary and appropriate for carrying out the purposes of the chapter. We think this falls under that. And then it says, provided, however, the Commission shall not require the reporting or disclosing of more information on any report than is expressly required to be reported or disclosed by this chapter. Okay, so that's a report required by the chapter. We cannot require more information on a report required by the chapter. This chapter, that's the Campaign Finance Act, Chapter 5 of Title 21, specifically refers to certain things as reports. Specifically, the campaign contribution disclosure reports, which are defined by law as the reports. So when it says any report that is required by this chapter, it's talking specifically about campaign contribution disclosure reports. I think that it would be fair to say that we would not also require additional information on declarations of intent to run for office that is required by law, or on personal financial disclosure statements. We do try to clarify that, but we do not require additional information. And in fact, I will tell you that we have changed our practices since I became executive secretary, and I'm not trying to take personal credit, but working with staff who have pointed out situations where we in fact are asking for more information than the law requires. We have changed that. Even last week, we changed one to not require more than the law requires on those reports, because those are the reports the law refers to. And it specifically defines something as a report, and that is the campaign contribution disclosure report. So when it says shall not require more information on any report than is expressly required to be reported or disclosed by this chapter, we think those are the reports it's applying that limitation to. If it didn't mean that, if report meant any giving of information to this agency, then those clauses that are in this subsection would not even be necessary. It could just say, shall not require reporting and disclosure of any more information than this chapter requires. That's all it could just say that. But it doesn't just say that. It refers to on a report. And that's what it means. It means the types of reports that we receive. These reports are not the reports of the filing officers. They are our agents, and they transmit those reports to us. So we do not think that we are running afoul of this limitation. I do want to stress that we wish to function within the four corners of the law, even if it's not the best way. Should it not be correct, we are not going to do it. If this commission says we don't want to do that, then we understand that and accept that. I can say that I want things not only to be legally correct, but also to be practically the best and most efficient method. Having looked at this problem now for 2 years, we've conducted multiple audits, state and local, to try to determine what the late fee situation is. I can tell you it is not possible under the current legal regime should this regulation not be permitted. For locals to determine who is late, as the AG's opinion says they must, and for us to then somehow magically know that and send out appropriate late fee notices. We couldn't do that. And we want to do that. And we have put all the other pieces in place to do that. I can say, and I will let them speak for themselves, that the only opposition we've received from this rule is opposition from or organized by the Georgia Municipal Association. I don't want to speak for the Association of County Commissioners of Georgia. I will say they have said they're not going to opine on this rule, and so they're not opposing this rule. And in fact, I will tell you lastly, with great respect to the cities, who I think that the clerks of the cities have an enormous burden. And frankly, I wish they weren't burdened with this issue at all, because I think it should all be just directly reported to us, end of story. Mail it to us, enter it on our system electronically, but don't even go through the clerk to send it to us. I think that would be the best way. That is not the way that GMA sought to set up the system. And in many instances at the municipal level, there may be nothing to report because many of the officers at the municipal level can file a $2,500 affidavit. They do not intend to receive contributions of $2,500 or more, and so they do not have a filing obligation in the general sense. And the municipalities can always just say to us, we got nothing to report because nobody's late. And if they make that statement to us, we would have to accept it. You know, bound, unless there was some other credible, concrete evidence they were lying to us, we would have to accept that. So it's an easy thing, I think, to do, and this is information that I think the locals have and have told us they have and can provide us. Thank you for considering my thoughts on this.
Thank you, Mr. Ritter. We have some members of the public that have come to comment. So I'm going to take them in order that you all have signed in. So the first up is the City Clerk of Johns Creek, Ms. Joan Jones. Thank you for coming, by the way.
Thank you for having me. I appreciate it. This is my first time here, so I'm excited to learn the process.
You're welcome.
Like Madam Chair said, my name is Joni Jones. I'm the City Clerk for the City of Johns Creek. I've been certified as a municipal clerk since 1999. I do have some questions about and concerns about the process of how this program will work. If it's electronic, is there computer software? How will it be compatible? Is it as simple as an email? I know Karen Jordan, our president-elect, will be speaking about some other issues, but I do have a couple of questions in response to Mr. Ritter's speaking, and I apologize, I don't see a timer, so please give me a sign, I'll be sure to be quiet. One of the things that I understand, that y'all get the report when someone is late and they come in and file the report, we send it through the e-fax systems or what have you. Years ago, we used to have a statement 5 that would have all the lists of the folks that didn't file, and you would have it that way. So I think there might be a way that we can work together to get a better system. But I also don't think it's fair to penalize all of the city clerks for some folks that are not doing their job. Sometimes it's a matter of communications. There's a lot of turnover at the city clerk's level. In the smaller cities, they do have a lot of things going on. I do think education and communication is key to any projects or programs working together with agencies throughout the state or locally. The other thing that I wanted to find out was the
Ms. Jones, I have one question just
Yes,
to get
ma'am.
some clarification.
Please.
So you said you felt like this might penalize the city clerks because there's a lot of turnover. By that, do you mean that the city clerks are being penalized for individuals who are?
No, ma'am. What I
Okay.
mean by that was that Hyde Park was the Georgia Carl Vinson Institute with the training for our clerks. We have new clerks coming in September and in February, and they average 30 to 40 new clerks each session, so I know that there's a lot of turnover. What I was concerned about, if there are some city clerks, filing officers that are not doing their job, or you're not getting the reports that are due, then that needs to be communicated to them or their elected official so they can be aware. Maybe they're just not aware that they're supposed to be reporting. For the whole thing to change just because of a few. That was my concern.
Okay.
And the other thing is unfunded mandate for the time. If it's going to be a simple program, Is it gonna be costly? Will the computer program or whatever program y'all come up with, Mr. Ritter was referring to a simple email. That sounds like a fine idea, but I just think with everything the clerks have to do, it's just one more addition, one more hat that they have to wear.
Thank you. Anything else, Ms. Jones?
No,
Okay.
I appreciate your time.
Sure, any questions? All right, thank you. Again, thank you for coming. All right, next I have from GMC and FOA, it appears that it's Karen Jordan, is that correct? Okay. So- Again, thank you for coming.
Madam Chair, I appreciate you letting me speak and commission. I am, as she said, Karen Jordan. I am President-elect of the Georgia Municipal Clerks and Finance Officers Association and representing over 500 city clerks in the state of Georgia. After hearing Mr. Ritter speak, I think I humbly ask you to not act on this new proposed rule today. I think it would greatly benefit both of us, both sides, to sit down and discuss this matter in a meeting. I don't think there's enough hours today to sit down and do that. You all have other business on your agenda that I know that you need to attend to. I think this goes a little deeper than what we could address today. So saying that, I'm just going to respectfully ask you to table this decision today on this proposed new ruling. And at some point in time in the near future, sit down with maybe our board members and some other city clerks, because Mr. Ritter brought up some issues I have not heard of from any of the clerks about keeping fines or imposing fines or anything like that. And so, as I said, I think this goes a little deeper than what we can discuss today, and I respectfully ask that we have a sit-down meeting between us to discuss these issues before moving forward with passage of this rule.
Okay. Thank you. Appreciate it.
Any questions? Okay. All right, I have from GMA, Rusi Patel.
Thank you, Madam Chair. This is actually my first time speaking before you as well. I'm Rishi Patel with the Georgia Municipal Association. And I have a few items to discuss with you. We filed a comment and then an addendum to our comment, which hopefully you've had the chance to read. But in addition to that, I have a few other issues that I would like to raise. But first, going to our initial comment, we don't believe that the Commission has the authority to enact this specific rule. And I know Mr. Ritter has spoken in opposition of that position just a minute ago, but there are actually 3 different reports that are addressed in the statutes cited for authority. First, we have the campaign finance, then we have the financial disclosure, but there's actually a 3rd report in 21-5-6B19. And that's the report that's actually most accurately close to the report that's proposed in this rule. And B19 specifically says, the Commission shall have the following duties on a quarterly basis to prepare, update, and publish in print or electronically a report and post such report on its website listing the name of each filer required to file with the Commission who has not filed the most recent campaign contribution disclosure report required by Code Sections 21.534 and 21.534.1, a financial disclosure statement required by 21.550, or the disclosure report required by 21.573 within 30 days of the date such report was due to be filed. That is the report that is most closely related to the report proposed in this rule. And if you look at this B19, the only thing required in that report is the name, and it's the Commission that is responsible for that report.
But Mr. Patel, doesn't, and just to make sure I'm clear, this rule asks for, or this statute, I'm sorry, is listing the name of filers required to file with the Commission. And it's my understanding that local filers file with their clerks. So we could not publish that information because the statute doesn't contemplate that we have to publish the names of the local officials that have not filed their CCDRs, because
they are supposed to file it with the local clerk.
I agree that this report is not identical, and I'm not claiming that it's identical. I'm saying that this report is the most closely related to the report that is being proposed in this rule.
Okay.
This rule also is
I
not.
don't want to interrupt, but isn't that part of the point? Is that there isn't a per se report that is required on this subject?
And that is the point from our perspective, is that for the local filing officers, there's two duties the local filing officers are responsible for, and the major duty is to transmit the reports they receive from the campaigns or the candidates to the commission. That's the main duty of the local filing officer. What this proposed rule is suggesting to do is create a brand new report. And I know Mr. Ritter has spoken that it could be an email or it could be some other information, but if you look at the actual proposed rule, it says electronically report. And I mean, that's a report. There's no way around it. The statute 2156A7 was proposed to be amended in legislation this past legislative session in House Bill 399. And in House Bill 399, the proposed amendment, and this was a bill that was brought by the staff of the Ethics Commission, I believe. There was proposed to be language stricken from A7 that would specifically have changed the meaning of that paragraph to allow the commission to enact rules that specifically allowed for more information and more reports. So
If that was the case, couldn't the staff have just proposed legislation that would have clearly said that, hey, we want the report to be sent from the local filers up to the state?
They could have, if that was the only rule that they were wanting to move forward with, that would have been above and beyond current law allowed.
The only thing that really changed with the proposed legislation in the code section that you're talking about is it removed the date that was there with reference to the old rule from 2013, isn't that right?
No, it removed the date and also removed the provision that says so long as such rules and regulations do not conflict with this chapter. So it allowed for rules and regulations that did conflict with the chapter, because it would have changed that line to say, provided, however, that the commission shall not require the reporting or disclosure of more information on any report than is expressly required to be reported or disclosed by this chapter. So unless such, well, no, not that far. So basically would have given more powers to the commission on enacting rules. Beyond the statutory arguments we put it forth in our comment and our addendum to our comment, there are actually problems with the notice. Last Tuesday, I started receiving emails and calls from clerks telling me that they had been trying to fax the comment to the commission on the number provided on the initial notice. The fax number on the initial notice was 404-463-3935. That was a faulty fax number. It didn't work. And we discovered this last Tuesday. I immediately emailed Mr. Ritter, and to his credit, he emailed me back the correct fax number. And apparently he issued a new notice the very next day on June 7th. The interesting thing is the June 7th notice, which is the one that is currently on the website, still has some other errors in it that the original notice had. And it's a notice provided on June 7th for a meeting on June 14th. The Administrative Procedures Act requires a 30-day notice period. That's a new notice. It needs to go out. That new notice on June 7th did not go out anywhere. And I suspect the new notice on May 12th did not go out to the mailing list provided in the Administrative Procedures Act. So there are some procedural problems with how the notice was sent out. On top of that, the notice has some additions to it that aren't required by the APA. Both notices, whether the May 12th one or the June 7th one, say, quote, lengthy statements or statements of considerable technical or economic nature, as well as previously recorded messages, must be submitted for the official record. Oral statements should be concise and will be limited to 5 minutes per person. Written comments are welcome. Such written comments must be legible and signed and should contain contact information from the maker, address, telephone, fax number, etc. The actual APA says in paragraph 50-13-4A2, afford to all interested persons reasonable opportunity to submit data, views, or arguments orally or in writing. In the case of substantive rules, opportunity for oral hearing must be granted if the request is by 25 persons who will be directly affected by the proposed rule by a governmental subdivision or by an association not having less than 25 members. The agency shall consider fully all written and oral submissions respecting the proposed rule. It doesn't say anything about signing it. It doesn't say anything about if you're going to do a long one, you have to do it in writing. There's some technical defects with this notice as well. I believe that, and GMA believes that there are issues, first off, with the authority for the commission to actually enact this rule. Under the statute, the commission is very limited as to new rules it can enact. Failing that argument, there are issues with the notice, which I just went through. We asked when we sent it out to our members for them to copy us on any comments they sent to the commission. As of this morning, we'd received 76 comments. I don't know what number of comments the commission received because for the first few days that we had sent that out to our members, there was a wrong fax number on the notice. So we don't know if some people just didn't notice that the fax didn't go through. I can't tell you. I do know that Mr. Ritter issued a new notice on June 7th for a meeting on June 14th, and the APA requires a 30-day notice period. Going through all this, slightly related, slightly unrelated to this rule, we discovered that there's a number of issues with the commission's website that I know that the commission isn't responsible for. They have to work with the GTA, but I think they need to sit down with the GTA. Trying to find the proposed rule on the website, if you actually go to the search function and type in proposed rules, you would get to a screen that has a banner that says proposed rules, and there's nothing underneath it. The only way to find the proposed rule would actually be to sit on the home page and wait for the home banner to scroll through to the commission meeting notice. If you're looking for the agenda for this meeting, if you type in commission agendas, you get to a screen that has the banner commission agendas. There's no agenda there. You apparently have to go up to About Us, click About Us, then click About Us again on the next page, and then click a third link. It's impossible to find for a normal layperson.
But the APA doesn't require that it be published on the web.
It doesn't, but there's issues with the notice, and then this kind of ties into that where it's hard to find things, which is kind of the antithesis of the whole purpose of this body. I know one of the clerks here, Miss Karen back there, and myself, we actually found the agenda through the Twitter of the commission, not on the webpage, because there was a link tweeted out last Monday. That's just weird, and I don't expect most people would look at the Twitter of the commission. They go to the page. I agree with the clerks that have spoken that at the very least this needs to be discussed. We actually sat down for a few hours this morning that it would really be ideal for the clerks, ACCG, GMA, and the staff of the commission to sit down for a day, 2 days, how many days it takes to solve not just this issue, but all the issues that are related to filing from both perspective of the commission and from the local governments. That would actually solve it through legislation instead of a rule that I don't believe, and GMA does not believe, that the commission has the authority to enact. And I'll be glad to take more questions.
Have you guys reached out to Mr. Ritter about getting together to meet about this prior to this meeting today?
Not prior to this meeting. Quite frankly, we didn't have the opportunity to sit down and analyze this proposed rule until about 2 weeks ago. It was really strange, but Mr. Lane emailed the original notice to myself and about 5 or 6 other people, I think, on May 12th or 13th, whenever it was sent out. And I wasn't actually on the mailing list at that point. But other people in my office were, and they never received notice of this meeting. They didn't receive notice of the proposed rule. And I suspect that was common through other people that were supposed to receive notice through the APA. And that concerns me, because I'm glad I got it, because if I hadn't got it, no one else at GMA would have. because the people that were signed up to get it didn't get it. And that's a little concerning. I would be glad to sit down with Mr. Ritter. I just haven't had the opportunity to do so in the last couple of weeks. We have our big convention coming up in 2 weeks, and I've been swamped with that, unfortunately.
Okay, any other questions?
Thank you.
Thank you. All right, now municipal clerk for the city of Atlanta, I have Rhonda Johnson.
Sorry, Ms. Johnson had to leave.
Okay,
Okay.
all right, and I'm just for the, let's see. Are you, I can't read your handwriting. Are you Evelyn?
Yes.
And what's your last name? I'm sorry, Scott? Is it Scott? Okay. All right. Okay, so Ms. Johnson is not here.
Right.
Okay. Okay.
Madam Chair, will you allow me to speak on behalf of her in the letter that she sent to, me? Okay.
Sure.
I just wanted to, my name is Evelyn Scott. I'm with the City of Atlanta Office of Municipal Clerk. And I'd just like to read just a few excerpts from the letter that she sent, actually opposing the proposed rule. And basically her letter, just to read the brief excerpts from it, that most of the reporting is already required and outlined in other proposed rules such as OCGA 21-5-6, 21-5-34, and 21-5-50. And under the current law, city clerks are not responsible for creating or completing any additional reports, and the proposed rule directly contradicts state law as required by the city clerks to submit the monthly reports of late filers of required campaign and personal financial disclosures. Lastly, she's just asking that the commission consider, as well as placing this responsibility back on the elected officials to file directly with the Georgia Government and Transparency Commission. And she feels that this is the logical authority to determine the adherence to the filing deadlines, because as the commission does, they regularly maintain the training responsibility and governance for making the decisions on the imposed penalties if candidates actually file late. So I just wanted to give you that brief excerpt from her letter that was sent, and she just asked for this additional, not to have the additional burden being put on the city clerk.
Thank you, Ms. Scott. Appreciate it.
Mr. Ritter, am I correct in understanding what you said earlier, that it was actually, I mean, from what I'm hearing there is a suggestion that the local officials really don't want the responsibility. It was, and back in 2013 or 14, it was GMA that made the push for that, right?
That's correct. And I don't think that most local filing clerks, certainly at the county level, and Mr. Edwards is here, maybe he can speak on that. I can tell you that they've spoken on behalf of one organization, which is a Municipal Clerks Association, but I've spoken directly to the Georgia Election Officials Association, and they are adamantly opposed to having the obligation to even receive any of this information, which is, frankly, I think the best rule for them not to have it. But that has to take a legislative change, and we look forward to working with GMA and ACCG to do that.
Yeah, Mr. Ritter, I have a question as well.
Sure.
Can you just speak to the issue that the commission lacks the authority under state law to adopt this rule?
Well, I do disagree with that, and I will tell you that I don't think that they have actually clearly raised that in the argument today, though they did in writing. Let me just make it clear. We have the authority to, that is, this commission has the authority to enact regulations that are necessary and proper to fulfill its obligations. The only exception to that is that, and again, I will quote this, discuss this, the only exception to that is if we should not require the reporting or disclosure of more information on any report that is expressly required to be reported or disclosed by this chapter. So on a report that is expressly required to be reported or disclosed by this chapter, which they just admitted this is not, we could require more information on those. There are, in fact, specific reports that the Campaign Finance Act refers to. That's this chapter. It refers specifically to campaign contribution disclosure reports. It defines them as the reports. And those are filed by filers. Those are not the filing clerk's obligation. Again, I would emphasize to you, filing clerks are in a very different relationship to us than the filers. The filers are the people who file the information. It's their information. The filing clerks function as our agents. They have an agency relationship. And it's, I think, unheard of for an agent not to have to disclose their fundamental information that they have to the principal, which is us. We're the ones who are responsible to have this information. And I don't think the law was set up in a way that was supposed to be nonsensical. But that's what they're suggesting it is. And again, only these cities that have been organized by GMA have actually opposed that. It's actually a minority of cities. If you wish, I'd like to, I know there may be more clerks who won't speak, but there were several assertions that were made that I would like to very briefly address, if I may. Madam Chair, I can wait. I want to say about the notice. First of all, Mr. Patel has claimed that we don't have a valid notice. That's not correct. The notice was timely, it's never withdrawn, it's appropriate. But that's not an issue. I don't know why there would be an attack on staff, but that's not appropriate. And I can tell you the phone number that was on that notice, I have investigated it. When this notice was prepared by Ms. Sandberg and Mr. Lane, I believe that they understood that phone number to be correct. In fact, it may have been a correct phone number because we just moved our offices during the period of this notice. And we checked to see whether that was an active fax number. Apparently the people who did our phones disconnected that as a fax number because we had another fax number. So we provided that to them. There was no problem, as you know, with them getting notice comments to us. That's not an actual thing that's happened. All the other complaints that Mr. Patel had, I'm sorry that they had a hard time finding it, but the fact every single one of those related from us trying to go beyond and above every single statutory duty that we have. He got notice on Twitter. We don't have an obligation to notify people on Twitter. He got email notices to folks from Mr. Lane. And in fact, we try to compose and keep a list of active people, we don't know when they change, that we send out a gratis, without any obligation, notice of these things. We do, of course, put it on our website. It's not a requirement that we do that. We post it on our board in front of our office as legally required. It's always been up there. There has been no problem with people finding out about this. This is not a basis to attack the regulation. I think if there is a legal basis, it's because people would disagree about what that phrase "on any report" means, and I would understand that. I don't think the other ones are viable arguments, and we would have welcomed before this meeting a chance to sit down and talk with them if they wanted to. But the only thing we can say is we are very happy to receive any informal email that gives us this information. Tell us who the people are that we can identify who have not filed. That is not 21-534 or 21-550 report. And so we disagree with them about that.
Would it solve that problem if instead of saying shall electronically report, say instead shall electronically disclose or shall electronically publish to the commission?
Yes, and if I had anticipated that we would receive this objection, we would have chosen a different word there in that regulation. I think disclose is a better word than report. Because if we're not creating a report, report is a term of art used in the Campaign Finance Act, specifically referred to the campaign finance or contribution disclosure statement. So yes, I think that was an inartfully chosen word. That's completely on me, but I frankly did not anticipate this objection. So
if we change that word then to say disclose, we would need to do anything further?
I don't think so. And I will state here on the record that while we say that in a format consistent with the directions of commission staff, we just want to make the authority crystal clear because we want to tell people, hey, send us an email. That's fine. Send us, a letter if you want. You've got to tell us who is there. And there's a lot of other nuances I could add to this, by the way, which I'm not going into unless you want to hear about them, like the fact that knowing who is late or who has filed or who has paid a late fee is not consistent with the statutes 21-534 and 21-550 that set filing deadlines because people file late or pay those fees all the time. So we don't know who it is. So we'd be sending notices to folks who in fact have filed, but we're not told they have filed because according to GMA, that filing sort of should be kept secret. And we don't know that, nor can we go back and somehow compare who has filed when we receive it from who was supposed to file, because again, we cannot compose a complete list of who has those filing obligations at the local level. Working with the Secretary of State, which we've done extensively, we can at the state level and have.
Yeah, Mr. Ritter, do you have an opinion on whether meeting with the people who objected to the rule before the commission makes a decision on the rule would be productive?
No, I don't think it would be productive. And my concern today, of course, I'd be happy to do that should you direct me to do it, but I will tell you, I think all we can say is we've given you a simple rule. Maybe you misunderstand it because we're not asking to change any other obligations. Saw the form letter. That's not correct, what you state in the letter that was drafted by GMA, because we're not changing those obligations under 11534. But most importantly, from my perspective, in a timing matter, we propose this rule now because we wanted to have it in place by the end of this fiscal year. This fiscal year ends June 30th and begins July 1, is the 2018 fiscal year. So we want to have a clean start. And it so happens that statutory reportings that happen, that are actual reports that are filed, that happens at the end of June. There are CCDRs and personal financial disclosure statements that are due at the end of June. The first time the PFDSs will be due will be at the end of June. So we're looking, really wanting to have a rule in place before then. Frankly, we could have a rule in place in September and say it was retroactive, but I think it's better to give them notice. And that's what we're seeking to do. And I want to say one other thing. One thing this rule does not say, and I don't think it should say this because we don't need to go there, but one thing this rule does not say is that we're seeking a prospective going forward reporting as to who's late. Not retroactive, like tell me who was late in 2012. I want to know going forward so we can get on a good going forward basis where we're at least caught up on that and not adding to the burden of late fees not collected because we don't know. So that's what we're looking for. But the rule, I admit, does not say that. And that's because we didn't want to necessarily limit it that way, but frankly, it's a practical matter, that's where we're going with this, and I'll state that officially on the record.
Last thing, and I'm sorry.
No,
I don't want to belabor this any longer than
Yes.
we have to. You mentioned earlier when you were talking about the audits that have been done on local filing officials and whatnot to
Right.
See what hasn't been collected. Did you make a reference to millions of dollars that have gone uncollected? Or tell me about that.
Yes, absolutely. So what I learned, and it was news to me when I started 2 years ago in my position, was that late fees was a huge issue, and in fact, by and large, the commission had not been collecting late fees at all from folks who were late for years. We ran numbers on this, and I think that there are problems with some of the numbers, and I've discussed this at some of the meetings, of course, before your time as a commissioner, sir, but there are problems with the numbers because of they're under-inclusive rather than over-inclusive in some respects, but they're also over-inclusive with people who should have been off, but were not taken off the computer system. In any regard, we ran the numbers, and if you include lobbyists, the number was over $7 million.
What about locally, though? That's what I was...
It's several $1 million locally.
Okay, and the other part that I'm just curious about is,
Right.
Are we talking about uncollected local money since 2013 and 2014 when the change was made to file locally?
No, that number goes back through what statute of limitations, and so of course that changes. Statute of limitations, for your information, for a 4-year office, and most local offices are 4 years, is 5 years to bring that case.
So, I don't want to cut you off.
Yeah, no, that's okay.
Do we
But
know
so what we did was we time limited it by the 5-year going back. So it's not to 2013. At the time those numbers were run, it probably ran back to 2011.
Do we know what the uncollected numbers are locally since the change was made to require local filing?
I could not give you that number except to sort of pull it out of the air, which I can tell you I believe it is in excess of $1 million. And I also believe that were late fees to be appropriately collected, we would be talking a minimum of several $100,000 plus just local a year. And that may be why there is opposition to this rule. But that's the fact. Thank you very much for considering my thoughts. Thank you.
Yeah, I have a couple of observations. Number one, I think I'm the only person on the board that was here before we had to make it dark. And the commission did not.
Is that how you got all your gray hair?
So I would say I'm unpersuaded that we did not have the authority to make it. I lived through a time when we couldn't make any rules. I'm also believe that adequate notice was given. So those two things that are set forth were not persuasive to me. But what I'm interested in is we can pass this rule, but we have a multiple people who have called in and reading these letters and these resistance to the motion or to the rule change. I believe that the clerks are thinking that they have an obligation that they do not have. Do you agree with that, Mr. Ritter?
I do. I think that.
Now, let me tell you, the leaders of the GMA have obviously they are concerned about the workload of their clerks. I think Ms. Jones, I think it was, pointed out that they would love to sit down and talk. I appreciate us wanting this done before the fiscal year ends, and I appreciate that. But I'm moving down the road. I want to accomplish two things if we can with this rule. I want the commission to be able to execute its charge that we have about fairness in filings and fairness in fines. We have a system that's not fair. Some people are not paying and some people go under the radar. It's not fair to people that pay. So I want this commission's job made more efficient. I appreciate that the clerks don't want to be have engrafted upon them and their city leaders some extra work that they haven't heretofore done. Now, having heard these people and these dedicated public servants, and I know about your service, Mr. Ritter, I believe if something could be hashed out where the things you've said, the rule really doesn't mean that, we've changed that word. I think if that comfort level was given and some tweaking done to this rule and effective notice be given to the cities, I think we'll have something that will make their work easy to do and fulfill our charge as a commission. So I would like that opportunity to be explored by everybody to see if we can arrive at that. And if it comes into September, that's great. But then we'll have something in place. I'm afraid if we start, I'm not afraid, I would not like for us to start now with a rule that's misunderstood and resistance come toward the commission and people say, we're not going to do that, they really don't have authority, and then somebody files suit and say we can't do it, and then we'll be in another mess. But I think we can have something very efficient and crisp and can get it done without burdening everybody, and still we have an obligation to the citizens of the state of Georgia, this commission does. And we want to carry it out. And by the way, the people that elect these municipal people who put their clerks in place, they have a duty to their citizens. And we can make those duties mesh and do right, I think, if this rule can sit down where everybody understands it. We're not doing anything overreaching. This rule, the intent of it is not overreaching. The intent of it is efficiency. And I think it's totally misunderstood, not totally, but I think GMA and its representative cities understand that. The counties evidently have not seen too much problem with it. But we're talking about 159 of those, and goodness knows how many cities. So
at this time, it is 12:22. That leaves us with numbers 8, 10, and 11 left. with regard to the consent orders, if there's anyone here from the public that's here with respect to their consent orders, I would be fine taking those before we do a quick break, unless any of the other commissioners need a break.
No.
Okay. Like, are there any?
Mr. Belton's counsel, Doug Chalmers is here.
Okay, so that is number, that was moved, correct? So that is 5D that is being moved down to 8. So let's take Mr. Belton's matter. While you and Mr. Chalmers are getting settled, anyone that was here is welcome to stay. We love having people here, but if any of you feel like you need to leave, and you were just here for the rule, feel free to go ahead and do so.
That's fine.
Oh, you'll have to. I pretty forgot how you pronounce it.
Did he say crying bull?
No, he told me his assistant wrote down like how to say it, and it was, what was it? It was a crying bull?
It was.
Okay, good.
And I told him that was correct on so many different levels.
Okay, all right. All right, Mr. Lane and Mr. Chalmers, are you two ready to go? All right, let's go.
Commissioners, this is the case of David C. Belton Jr., 2014-0018. The commission began this case once it received a complaint on March 31st, 2014. In that complaint alleged that Mr. Belton, who was running for the state representative district 112 seat, but who was also an incumbent for a Board of Education seat as well, had begun collecting campaign contributions prior to the filing of his declaration of intention to accept campaign contributions for the state house race. We reviewed his financial data. We confirmed that in fact he did take 5 contributions. They were fairly small, but he did take 5 contributions prior to the filing of that DOI. Mr. Chalmers can address his opinion on whether the filing of a separate DOI for the Board of Education covers the State House race. We maintain that it does not. Each elective office gets its own separate DOI because you're not allowed to commingle funds for the 2 respective offices. But be that as it may, we've all agreed that there was a violation, or at least that it's not going to be opposed on Mr. Belton's part, and that Mr. Belton will pay a $400 civil penalty for the commission for the acceptance of those 5 campaign contributions prior to filing a DOI.
Okay. All right, Mr. Chalmers.
Thank you, Madam Chairman. The only thing I have to add is that my client has decided voluntarily to pay this out of his personal funds rather than campaign funds. We advised him that he could do that out of his campaign funds, and he has decided that he doesn't want to have his contributors paying this penalty, and so I just wanted to commend him on the record for that. We did believe we have a legal defense here. We believe that the law actually does not require a sitting public official to file a new DUI for a new office. It is written that way, but our client has decided he would prefer to settle the matter at this point, and therefore we are withdrawing that defense in this case for that purpose.
Thank you. All right, we don't need to take a vote on this.
Yes, you do.
Yeah, you do. We do? Oh, okay. All right, well then, all in favor of accepting the compliant, is it a compliance agreement or consent order?
Consent order.
This one's a consent order, okay, but the consent order of David C. Belton Jr. Or I guess we need to make a motion first, right? I'm getting hungry.
Well, you moved for it, so you just need a second.
I did, so I need a second.
I'll second it.
Thank you. All in favor? Aye. All opposed? All right. Okay, anyone else that's here for the compliance agreements and consent orders? We'll go ahead and take those.
Case, it's 8C 2016-0051 in the matter of Johnny James Searcy. The complainant, Mr. Brian Pritchard, is here.
Okay, fantastic. Mr. Pritchard, yes, if you'd like to come up and take 8C.
First of all, thank you, Commission. I appreciate the work that you do, and I understand the caseload. One, I did file a complaint, and I just want to make a brief statement. This commission has notified me all the way through. I made 3 complaints in one race, and let me give you the races. The Fannin County Sheriff's race, there was 3 complaints filed on 3 different candidates in the same race. I had no way to file a joint complaint concerning this race, so they were all individually. You've handled 2 of them, which I respectfully said disagreed with, because one of them you handled with a compliance, and as the person that sent you the complaint, I never got a copy of the compliance, so I don't know the rule there. You notified me all the way through. You sent me a copy saying there was a compliance order put in place, but I don't know what the compliance was. So before I leave today, I will make a public open records request for that. Second, the one today, which the bottom of the letter says I was welcome to call if I had any questions, was set up for preliminary hearing. Mr. Searcy obviously made a deal, or whatever, however it's said, made a deal, and it's been moved over to a compliance on the agenda, which also today, 3 that were on the preliminary hearing schedule were moved over to compliance as you started this morning. So how was I to know it was moved over from that a hearing to a compliance order? That being said, this gentleman ran for office 3 times, the same office. There's a couple of things here before you accept this compliance order. One, he is the chief of police of the city of Blue Ridge. He's been the chief of police for 15 years off the top of my head. He has run for sheriff 3 times. He has filed multiple, over the years, he has filed multiple campaign finance reports. Multiple ones. This was nothing new to him. Not to take too much of your time, which I'm willing to stay all day, I drove 2 hours. I sent a full report of $5,000 worth of publication that was not put down in kind. All 3 candidates, which the other 2 are not on your list today, so I won't take your time, that would be Jack Taylor, Larry Bennett, and Johnny Searcy, my opinion, tried to manipulate the sheriff's race, and it did not work out. $14,000 worth of publication. There's nowhere in the ethics to say how I file anything against a publisher. $14,000. This individual, $5,000, 0 on his campaign finance form. When he filed that, and I pulled it, and I filed the complaint, not to quote what the commission does, they were offered to refile an amended form. He refiled it knowing what he had done, my opinion, exactly the way he filed it the first time, all 0s. I don't know if he thought the commission wouldn't catch that. Obviously, you move forward with what you're here today. $5,000 unreported, a city official, and it becomes $14,000 total in this publication. I oppose your consent order today. I don't know what, I mean, he's consenting to. I don't hear that. I don't know what it is, but I mean, I would answer any question that you may ask of me. I filed the complaint. I pulled the publication from the day he qualified for this office. I went to the publication, and this is what you received. And I pulled every single ad of this candidate. Every issue I have a copy of. I made you copies, part of my exhibit. I then went and got the publication's rate sheet. I had an independent person in the newspaper business, take the rate sheet and give me an independent total, which came close to $5,000 for this one candidate. All right? I sent that to you. Pulled every one. Now, I'm going to say on the record with the camera running and everything, sources, and I know you don't rule on sources, and I know we don't want to talk about collusion and manipulating an election with everything we hear in the news every day. But this individual, I understand, if his, what I hear is if his credit card statements were pulled, you may find this publication's print record paid for by this candidate through a credit card. Zero. $5,000. I'm sorry, that is not a compliance or whatever it's listed today of a fine. I don't know, obviously maybe it's first offender and these are my words, I don't know how the commission works, but we're talking about somebody that is chief of police of Blue Ridge, Johnny Searcy, 15, 18 years, has run for this same office and has filed reports for this same office in this same county for 3 different elections, and I got into this one. So I actually oppose what you're doing today in all due respect. In fact, I've actually got to enjoy sitting here listening to. So I'm here for any questions if you have any, whatever you may. So that's my statement.
Thank you.
Thank you for coming. We do appreciate it when the members of the public come that have filed complaints, so we appreciate you.
I would like to ask a question.
Yes, sir.
You answered it from back there.
Well, I can't see you from back there. I apologize.
Oh, okay. You said you just got into this.
No, I'm sorry. Oh, no, I got into it in this past election. I apologize. The last 2. I guess when I say I just got into it, I don't remember exactly how I stated that.
Did you run?
No.
You got interested in the race?
No, I follow all the elections in the local county, and I pull all their campaign finance, and, you know, I guess I'm pretty boring, but I pull all their campaign finance, and I read all of it, and
I'm just interested. We are interested in the integrity of the process, and we're a transparency commission. You just accused the sheriff's candidates up there trying to manipulate the election.
Oh, absolutely.
Yeah, so tell us how they did that.
Okay, well, there was 4 candidates, okay? So I'm going to tell you how. I accuse them, and I do it publicly, and I've done it publicly there. There were 4 candidates. There's a current sheriff that was running for re-election. Obviously, a couple people did not want him to get re-election, so there was an attempt to push the candidate into a runoff with candidates, which is not unusual. But these particular candidates, my opinion, I want that to be clear, they got together, and if you went to all 3 of these candidates, I filed a complaint on all 3. That would be Larry Bennett, Jack Taylor. Jack Taylor got 7,000. They got together with this one publisher, okay, in the county, and published approximately close to $15,000 worth of advertising in a rural county. 3 candidates. Now the sheriff, the current sheriff that won election, he did not take out any ads in this publication. It's well known, and it's not fair to say, it's well known that these candidates and the publisher met in his office all the time, a small county, you know, you see all the cars parked out front. So when I say accusation, but I have proof that I sent this commission of $15,000 of advertising. You got this.
Other than the publications that were, you were referred to as in-kind contributions.
But they were never listed in kind, sir. And I just want to know that.
I said they weren't reported.
Right, right.
Did you catch them doing anything else nefarious other than that?
No, I don't want to use the word nefarious.
Well, use whatever word you want to use.
Well, I don't want to say that. I mean, you know, if you pulled up to the publisher's office and all 4 were in there in a meeting, and if
that's the publisher, though, that you found.
Right, and so forth. But nefarious, other than going around to different public forums, and you could see they were together, unified against the sheriff, which I can understand. Anybody would say, well, we're running against him. And I want it on record, I'm not here defending a sheriff or any particular candidate or endorsing a candidate. I just watched them. I went to every forum. I go to every single forum. I pulled all this information, and I know you keep saying referring back. Maybe in Atlanta, no disrespect, or Gwinnett and areas of that nature, $15,000 worth of in-kind advertising unreported is not a lot. But in this rural county, it's an enormous amount when a candidate doesn't spend but a couple thousand total. And the one thing I did leave out while I'm back is in this individual that is here today, this individual's file, which I have, this is the one person alone, they report the other publications they spent money with. They report another newspaper, it's listed, they report radio stations. So when you say nefarious, the other candidates, which are not here today that you're talking about, Jack Taylor, which you did do a consent, I didn't get a copy of, and Mr. Bennett, you accepted a refiling. They, on their campaign finance reports, they reported other publications.
Thank you.
They all missed this one for $15,000.
Thank you.
Ms. Watson?
Thank you, Mr. Pritchard, for coming. I appreciate that. I think Mr. Pritchard left off one important detail, that he owns a news outlet called FetcherNews.com, I believe.
Yes, yes.
Okay. So, as you can see, this is case number 2016-0050 in the matter of Johnny James Searcy. It's a consent order. The complaint was filed by Mr. Pritchard on August 9th, 2016. Mr. Searcy was a candidate for Fannin County Sheriff during the 2016 general election cycle. He was unsuccessful, as mentioned before. Mr. Pritchard's complaint alleged that Mr. Searcy failed to disclose contributions from a news outlet or failed to disclose expenditures made to a news outlet, and that was the Fannin County Focus, which is a newspaper in Fannin County. During the investigation of this complaint, the publisher was contacted and spoken to by commission staff. And one thing to note is that Mr. Pritchard came up with a number of $5,000, that Mr. Searcy did not report $5,000 of expenditures to Fannin County Focus. Well, when speaking to the publisher, he said, I was happy to get business because I gave everybody that ran in that race and published with me a discount. He's like, I'm just happy to have some, it's a fairly small newspaper that doesn't get a ton of business. And
That's not the legal arm of Fannin County?
I don't think so. From what I understand, it's a fairly new paper. So he just was happy to have business. So although there is a rate page that Mr. Pritchard provided, especially in small towns, I'm from a small town, a lot of times those aren't followed when circumstances arise where they're just happy to have business. So what we determined is that actually he failed to disclose $1,647 in expenditures. When speaking to Mr. Searcy about this, he responded immediately to the complaint and admitted that yes, he neglected to disclose these expenditures. He was highly embarrassed. It was an oversight, and he accepts full responsibility for that. And he even said it's even more embarrassing that I've done this before. And it just completely, he just overlooked it. And so he amended his reports to include that amount, where he paid totaling $1,647 in advertising expenditures to the Fannin County Focus. So he took responsibility, looked at his CCDRs, everything basically added up. They're good as far as they're substantially compliant. No other issues were found. He's closed his campaign. So the two allegations that were substantiated is that he violated OCGA 21-5-34 when he failed to disclose all expenditures made during the reporting period on his March 31st, 2016 CCDR and his June 30th, 2016 CCDR. He agrees with the conclusions of law, and he has agreed to pay a $300 civil penalty, and I believe he has already paid that amount.
Okay. All right. Anything further? All right. I I will move then that we accept the consent order of Johnny James Searcy. Do I have a second? Okay, all in favor? Aye. Okay, anyone else here for the compliance agreements and consent orders so that we can get through those? Okay, all right, why don't we take a 15-minute lunch break, because that has us back here at 1 o'clock. And, well, I guess a little more than 15 minutes. So we'll start back at 1 o'clock and then hopefully finish up quickly thereafter. So we are adjourned. Okay.
Commissioners, this is, these are actually two cases that were combined. Case number 2012-0014 and 2012-0061 in the matters of Osborne and Nesbitt. Both complaints were filed by Sam Smiley in 2012. Because they were filed in the same year and they concerned the same election, they were combined for resolution. At the time of the complaints, the respondent was the incumbent Rockdale County Commissioner for Post 1. 2012 was an election year for him, and complainant was, actually the complainant was challenging the respondent in the 2012 election. The two allegations contained in the complaint were that respondent accepted a contribution from a public agency in violation of OCGA section 21-5-30.2, in that he failed to disclose a contribution on his June 30th, 2012 election year campaign contribution disclosure report in violation of OCGA section 21-5-34. We investigated the allegations. They were substantiated. The contribution from the public agency is that he used his county office address on his campaign push cards. Once he was made aware that that happened, he immediately changed the address to his campaign address, and it was a mistake. And then the second allegation that he failed to disclose a contribution on his CCDR was also substantiated. It was an event held by Resurgence Risk Management. They hosted a fundraiser for him, and he did not disclose any in-kind contributions in relation to that. Additionally, a notice of additional allegations was sent to notify him that he failed 1 CCDR late and 2 PFDSs late. Late fees have been assessed, and he has some outstanding late fees in connection with that. In resolution of the complaint, he has agreed to pay $750 as a civil penalty and to pay all outstanding late fees. I would ask that the commission would accept this consent order to resolve cases 2012-14 and 2012-61.
Is Mr. Nesbitt here?
He is not, and he was represented by Attorney Dwight Thomas.
Okay. All right. Okay, then I'll make a motion that we accept the consent order.
Second.
All in favor? Aye. Dennis? Okay. All right, sure. Any opposed? All right. Okay. All right. All right, moving on then to, in the matter of Virgil Watkins. And is Mr. Watkins here?
He is not. I've actually never spoken to him. Yesterday, I received an email that notified me that he had accepted the consent order, and he faxed, scanned a copy of the signed order. Mr. Watkins is a Bibb County Board of Commissioners. He's on the Macon-Bibb County Board of Commissioners. Prior to that, he was a Macon City Council member, and then when it was consolidated, he was elected to the commission. He has served on the city council since 2007, and then has continuously served in some capacity since then. The allegation was that he failed to file some disclosure reports that was substantiated while auditing his account. It was noticed that between 2012 and the present, he has failed to file 14 CCDRs, and he filed 4 out of 5 personal financial disclosure statements late. As a result, $1,875 in late fees were assessed for not filing the campaign contribution disclosure reports, and $500 in late fees were assessed for the personal financial disclosure statements. He did not dispute the allegations, and they have been substantiated. In resolving this case, he has agreed to pay $5,000 as a civil penalty and then also pay $2,375 in late fees. So I ask that the commission would accept this order.
Okay, I'll make a motion that we accept the consent order. Any seconds?
Second.
All right. All in favor? Aye. Any opposed? All right. Moving on then to, in the matter of Marianne Whipple-Lou.
And this is case number 2015-0062 in the matter of Marianne Whipple-Lou. She is currently the mayor of the city of Gordon. The complaint was filed by Alicia Floyd in 2015. The complaint contains several allegations. A lot of them.
The complainant's not here?
She is not here, and the respondent is not here either. The complaint alleged several things. A lot of it has to do with homestead exemptions, and also whether if they really are a resident of the city of Gordon. Of course, we do not handle those types of allegations, and I think this is a way for her to get those before people. What we did find is that she failed to disclose property owned by her spouse, Basil Liu. He actually owned property in an adjacent county, and she failed to include those on her personal financial disclosure statements in 2012, 2014, and 2014. Unfortunately, her husband died in 2015, and because he was alive and owned the property in 2014, she still had to include that information on her PFDS that covered 2014, and those were all violations of OCGA. Section 21-5-50B4 capital B, where it's required that you disclose property that you own that's valued over $5,000 and include your spouse's property also. So to resolve this fee, she's agreed to pay $100 as a civil penalty, and I ask that the commission would accept this order.
Okay, I'll make a motion then that we accept the consent order. Do I have a second?
I'll second.
Okay, all right, all in favor? Aye. Any opposed? No. Okay, all right, thank you, Ms. Wetzel. Okay, moving now to in the matter of Michael Ray James.
Commissioners, you have before you case number 2012-0047 in the matter of Michael Ray James. Mr. James was the District 19 State House Rep candidate during the 2012 general election cycle. He was unsuccessful in that race. The commission began this case upon receipt of complaint back in 2012, in which the complainant alleged that Mr. James failed to disclose his campaign contributions on his June 30th, 2012 campaign contribution disclosure report, which would be a violation of 21-534B1A.
And is Mr. James here?
Mr. James is not here, nor is the complainant. Mr. James is representing himself.
Okay, thank you.
After reviewing Mr. James's records, he was notified by a separate notice of additional allegations that he had also failed to timely file his June 30th, 2012 campaign contribution disclosure report, and that he failed to file his campaign contribution disclosure reports for September, October, and December of 2012. Mr. James has stipulated to these violations and agrees with conclusions of law and the findings of fact. He's agreed to the payment of a $500 civil penalty, and of course the payment of the statutory late fees of $500 for the late filings of his reports. There is the payment of the civil penalties and late fees is subject to a payment schedule. The payment schedule is fairly lenient. It's $25 per month with an acceleration clause. The main reason for it being so lenient is, I'm not sure if you will recall, but Mr. James is the gentleman who went from Georgia to Alabama to Hawaii and now back to Alabama. And during the first 2 years of this case, all of our notices and what have you were going to the ex-Mrs. James, and she was leading everyone to believe that he was getting noticed properly, but not really. That's the gentleman in question. He's been very responsive. He's already begun making payments under his payment arrangement, and so he should have that paid in the not too distant future. We recommend that the consent order be adopted.
Okay. All right. Then I will make a motion that the consent order in the matter of Michael Ray James be approved.
Second.
I have a second for you.
Okay, and all in favor?
Aye.
Okay. Moving on to the matter of Sandra Lucille Murray. Is Miss Murray here?
No, she is not. She's representing herself.
Okay. And is a complainant here?
No, ma'am.
Okay. All right.
Commissioners, this is case number 2010-0061. Ms. Murray was the District 80 Georgia State House representative in the 2010 general election cycle. This is one of the last few backlog cases that we have lingering with us. Ms. Murray filed her declaration of intention to accept campaign contributions on or about November 12th, 2009 and qualified for office on April 26, 2010. The allegations against Ms. Murray is that she failed to register her campaign committee known as the Friends and Neighbors of Sandy Murray. That was a violation of the Commission's regulatory rule found at 189-4-.01, subsection 1. She failed to timely file her PFDS for 2009. She filed it, she was just late. And that, excuse me, but that she filed all of her other CCDRs and other filings during that election cycle timely and were otherwise compliant with the Campaign Finance Act. Ms. Murray has agreed to the conclusions of law and the findings of fact. She has admitted that she failed to register her Friends and Neighbors campaign, but she submitted everything else timely with it. She disclosed everything. She just didn't fill out the right document to register it correctly. She's already paid the late fees associated with her outstanding late fees, and we're asking for an additional civil penalty in the amount of $75 for violation of our regulatory rule. And I believe she's already paid that as well. And we just recommend that consent order be adopted as it is.
Okay. All right, any questions? Okay, I'll make a motion then that the consent order in the matter of Sandra Lucille Murray be accepted. All of those, okay, fantastic. I anticipated your second there. All those in favor? Aye. Okay, any opposed, like sign? Okay. All right, now we move to the matter of BB Ann S. High School.
Correct. Ms. High School is representing herself. She is not here, and there is no complainant because, well, I was the complainant. So that's a PC case. The commission initiated. The case number is 2016-0061 PC. This came about after the commission did an audit of Ms. High School's account, showing that Ms. High School had exceeded maximum campaign contribution limits. In fact, she exceeded the contribution limits on a total of 8 different transactions, totaling over $5,000 once everything was added up. Ms. High School has already expended the funds, but we are asking for a civil penalty in the amount of $6,000 to come directly from Ms. High School's personal funds, which my understanding she has already paid as well. She's basically, also she's refunding to the contributors who exceeded. We've had experience where that doesn't necessarily work, but she's more than paying it back through the fine to us. And that's the extent of the order.
Okay, and this one was just a random audit that occurred?
Yes, ma'am.
Okay, all right. Okay, then I will make a motion then to accept the consent order as entered, or as drafted, I guess.
I'll second.
All right. All those in favor?
Aye.
Aye. Okay, any opposed? Okay, moving on then to the matter of Vivian Crichton Bishop. Is Miss Bishop here?
She is not.
Okay, and the complainant?
He is not.
Okay.
Commissioners, this is case number 2012-0084 in the matter of Vivian Crichton Bishop. This case was opened upon receipt of a complaint in December 13th of 2012. Again, this was kind of one of the lingering old cases, and we're glad to have possibly some resolution to that today. You may recognize Ms. Bishop's name. She is the wife of Congressman Sanford Bishop. She's the municipal she's the municipal court clerk for Columbus, Muskogee County. She was at the time of the alleged violations in 2012, she was a candidate for elective office. And she failed to file several reports late, and specifically she filed her March 31st report late, and she failed to file a September 30th report, and she filed her October 25th report late. A lot of these, when they were filed late, they were just within a couple of days of the due date. Because of her tardiness, $375 in late fees were assessed. Also, she failed to timely file 2 personal financial disclosure statements, and as a result of that, $250 in late fees were assessed. So in total, there were 5 violations, 2 relating to late filing a personal financial disclosure statement, and 3 relating to filing campaign contribution disclosure reports. In addition to this, a notice of technical defects was issued to her, and she corrected all the technical defects. She was very diligent in doing so, and very patient, and really wanted to make it right. So respondent agrees to pay $150 as a civil penalty for violating, for filing her CCDRs late, and $50 for filing her PFDS late twice. And then she also has agreed to pay all outstanding late fees, which totals $825. The civil penalty amounts are a little bit lower because she did file somewhat within the time period, and also this is a very old case. So I'd ask that the commission would respect the terms of the consent order.
Okay, I'll make a motion that we approve the consent order in the matter. Okay, Ms. Bishop, all right, thank you for the second, Mr. Kathy. All those in favor? Aye. Any opposed, like sign? Okay, it's approved. All right, moving on to the matter of Griffin Watson.
Mr. Watson is representing himself. He's not here, and neither is the complainant.
Okay, fantastic.
Commissioners, this is case number 2016-0014, and Mr. Watson is currently the incumbent post-2 counselor for the city of Darien, Georgia. This case began on February 22nd, 2016, when the commission received a complaint from Mr. Jeff Clark. The complaint from Mr. Clark was amended by a notice of additional allegations on April 5th, 2017 by, of course, commission staff. Just by way of background, Mr. Watson had an older case with the commission that had been resolved and was in collection status. In that case, he owed over $1,000, and I'll circle back to that in just a moment. As far as the current case before you, there are 2 allegations, and they are that he failed to timely file his personal financial disclosure statements for calendar years 2011 and 2012. By operation of law, a $250 late fee was assessed for both of those, $125 each, so grand total of $250. He's also agreed to the payment of a $100 civil penalty. He was given credit for his older case because although the commission had not collected on that case and we were getting very close to the point where we would be unable to collect, he went ahead and immediately paid the entire amount due and owing under that old case and reaffirmed the debt. So we did give him a slightly lower civil penalty than we normally would on this new case in consideration of that fairly large payment. He's actually already paid the $350 he owes on this current consent order, and we simply ask that you adopt it as is.
Okay, I will make a motion then that we adopt the consent order in the matter of Griffin Watson.
Second.
Okay. All those in favor? Aye. Any opposed, like sign? Okay. Moving on then to, in the matter of Deborah Denise Thomas. And this looks like it's 2 separate matters that have been combined. Is that right, Ms. Wetzel?
Correct.
Okay.
Then the complainant and respondent are not here today.
Okay, thank you.
These are case numbers 2015-0048 and 2016-0056. In the matters of Deborah Denise Thomas, one complaint was filed by Larry O'Hara and the other complaint was filed by Rhonda Cross Scott. They both dealt with the same allegations. This is, if you would like to look up some drama, you should look up Clinch County Commission because that's a lot going on there, and this is a result of that. So respondent is a Clinch County Commissioner. She has been a commissioner since 2004. And at the time of the alleged violation, she was required to file personal financial disclosure statements. She filed in the last 7 years, or excuse me, rather, in the last 5 years, she filed too late. And as a result, $250 in late fees were assessed. These were the only allegations from the complaints that were substantiated. All other allegations dealt with property disclosures on her personal financial disclosure statements. She and her husband own lots and properties with trailers on them. A lot of times those are not more than $5,000. So those were what the complainants were really alleging, is that they failed to disclose a lot of properties. But after reviewing tax assessment records, they properly disclosed all of the properties that they did own. So the only 2 allegations that were left were that she untimely filed her personal financial disclosure statements. To resolve this case, she has agreed to pay $150 in civil penalties and $250 in late fees. And I would ask that the commission would accept the terms of this agreement.
Okay. All right. I'll move then that we accept the consent order in the matter of Deborah Denise Thomas.
Second.
All those in favor? Aye. Okay, it's been accepted. All right, now moving on to the matter in DeKalb Strong. Is there anyone here from DeKalb Strong?
No, there is not.
Okay, and the complainant is not here?
He is not here. He wanted to be here, but he is, like so many people, out of the country at the moment. So this was a complaint filed on February 8th, 2016 against a ballot committee, DeKalb Strong Incorporated. DeKalb Strong Incorporated opposed the La Vista Hills Incorporation referendum that appeared on the 2015 ballot. What the complainant alleged is that the respondent failed to register prior to accepting and expending funds to bring about the rejection of the proposed cityhood question. When looking at the dates as to when they did register and when they did accept their first contribution and make their first expenditure, it was substantiated that they did fail to register with the DeKalb County Board of Registration prior to accepting contributions. This is not really a huge deal. I mean, because one, this organization was widely known on the internet, they were incorporated, you could find out who was behind it. Also because the disclosure reports that they were required to file, they filed those all timely. So the only thing that mattered is that they just failed to register in a timely manner. And it is a big deal, but it's not so much because there was sufficient transparency in this case for individuals to be able to figure out who was behind the organization and what their purpose was. To reflect that, a civil penalty of $125 is recommended. They have agreed to pay this, and I've asked that the commission would approve this.
Who's the individual that's signed on behalf of DeKalb Strong?
Marjorie Schnook, she's the chairman of DeKalb Strong Incorporated.
Okay. All right, then I'll move then that we accept the consent order in the matter of DeKalb Strong Incorporated.
Second.
Okay, all those in favor? Aye. And any opposed, like sign? Okay, it is accepted. All right, we've now gotten through all of the compliance agreements and consent orders. We move on to agenda item number 10, advisory opinions. And that looks like that is number A is advisory opinion 2017-01, when to reset a campaign balance. And Mr. Ritter, you're going to briefly go through these, is that correct?
Very briefly.
Okay, all right.
So let me just say, first of all, that we do have 3 advisory opinions that are on the agenda. They are, in fact, all somewhat related. And all 3 of these advisory opinions originate from staff in my direction after we've received just so many comments from a variety of folks as to what the law was that they seem to warrant formal advisory opinion from the commission. The first one, in fact, is an issue that was the subject of legislation which did not go through in the last session because there's so much confusion on the part of the General Assembly. And that is what is the accounting period that they're supposed to follow in filing their CCDRs, and how and when do they reset the amounts that are on their CCDRs. The CCDRs, of course, show the contributions and the expenditures for their campaign. Georgia specifically follows the election cycle as its contribution period. And it does that statutorily. It expressly says that under OCGA 21-5-34B1D, which governs CCDRs or campaign contribution disclosure reports. Well, an election cycle is different than, you know, a calendar year or a fiscal year or a GAAP reporting year. An election cycle is often, in fact, a 2-year period or 4-year period for an office. So it can be multiple years that you're in this election cycle. And the law says that you file a reset based on the election cycle. And it defines the election cycle specifically under statute. The period from the date following the date of the election or appointment of a person to elective office through and including the date of the next election. So if the election's on November 4th, the next election cycle starts on November 5th, unless there's a runoff. When there's a runoff, the election cycle continues until the runoff is held and completed, and then it starts the election cycle at that point. So different offices can have different election cycles, but what that does, at least as I understand the statutes, is that it means that the CCDR history is going to show all the contributions that are going to relate to the campaign through that election cycle. And we try to make that clear, and I think this would help a lot of members of the General Assembly to know that this is our opinion on it. I've stated it orally in the past, and so unless the Commission would disagree with me, I think that's the result. And then we have some notes on the back as to the reset periods as to when those occur under the statutory law. We did not receive any comments on any of these. I don't know if Mr. Chalmers has any comments. He is here today, he's the only person. But we received no written comments on it. Thank you.
All right.
No comments. No comments.
No comments from Mr. Chalmers. Okay. Okay, then we need to have a motion then on this advisory opinion. So I'll move that we accept the advisory opinion as presented and make it the AO 2017-01. Okay. All right, all those in favor? Aye. All right, any opposed? Okay, then becomes our AO for first one for 2017.
Great. First one, and I will make sure that's distributed to the members of the General Assembly.
Thank you.
Secondly, AO2 deals with the question of what filing schedule is followed by a elected public official who is not permitted to seek re-election because they're term barred from seeking re-election. And I would acknowledge there's confusion in the way the code is drafted on this because it doesn't really address term barred officials. It assumes that you're going to run for office and that you'll be filing on the more complete schedule that is for an election year rather than a non-election year. But we don't think that's the correct reading of the law. In fact, we think the intent and understanding of the law is that officials who are term barred do not need to file on an election year cycle. It's a non-election year for them. And so under the specific explicit title, non-election year, since they can't be elected, they file on a non-election year cycle. That's our opinion, and I will also tell you that that continues even after you leave office. As long as you have money in your campaign account, you have to keep filing. So some people file for years after they leave office. And they would always file on a non-election year cycle after they leave office because they would never be up for election for that office until, and if they file a new DOI for it. Thank you.
Okay. Mr. Chalmers, any comments, or anyone else have any comments?
No, ma'am. Thank you, President.
Okay. All right.
If he has no comments, does that mean in the future that we can just accept that he agrees with these?
No, sir, but thank you for asking. The only comment that I would have is on something that's related. You all might want to consider including this as an issue. When you have a special election and it takes place early in an election year, we have clients who end up having to file September, October, December, even though they're done in June.
We'll talk.
So that might be worth.
Yeah, that is a very good point. We haven't seen that a lot, but you would, and I can tell you that we would certainly consider piggyback opinion that would relate to that as well.
Okay, then I'll move that we accept the advisory opinion and make it the AO 2017-02 of the commission.
Second.
Great. All those in favor? Aye. Any opposed, like sign? Okay, all right.
No.
Moving on to 2017-03.
Okay, thank you. This seems to me to be driven very clearly by the statutory law, but we've got so many questions in misapplications of the law that it should be stated expressly in an official opinion of the agency. So the question is, if a prospective candidate pays their qualifying fee from their personal funds, do they have to report that as a contribution? I don't think there's any question that if you have someone pay your qualifying fee for you, that is a contribution. And if you give money to your campaign after you qualify, or in-kind contributions and so forth, that's a contribution that you would report, even though it came from your own account. What about the qualifying fee? We think not. It's not a contribution based on the express letter of the statute. And the express letter of the statute treats the payment of qualifying fee from one's own personal funds as not a contribution, which is an understandable thing to do, since you would want to, in many cases, qualify before you begin raising money for your office. And many people, by the way, don't do it that way. They raise money first and then qualify later. But, and I will also mention, I'm sorry to get into the weeds, qualifying fee is different than a declaration of intent. Declaration of intent is filed with us to say I'm going to run for office. I'm opening a campaign account. A qualifying fee is paid to the state, to the Secretary of State's office, which is the formal fee required to run for the office. They're two different things. But the qualifying fee can be made without being a contribution, in our view, out of your own personal funds, and we recommend that as an advisory opinion of the commission.
Okay. All right, then I will move then to accept this advisory opinion and make it advisory opinion 2017-03 of the commission.
Second.
Okay, all those in favor?
Aye.
Aye. Okay, any opposition, like sign? All right, then becomes advisory opinion 2017-03. Right, moving on then, and you know what, Mr. Chalmers, I assume that you did, because you didn't jump up, you did not have any comments on that one.
No, ma'am.
My apologies. Okay, I'm okay. Fantastic. Item number 11, the report of the executive secretary.
So let me begin with administrative dismissals. This is just a summary for, just for your records. I received this from staff yesterday after we had gone through this. Well, I put it together from what we received yesterday from staff. That's just a summary of the cases that have been administratively dismissed. To remind the commission, cases are administratively dismissed by rule of the commission through action of the staff, specifically the executive secretary, if there was in fact no jurisdiction or no factual basis at all to support the complaint. And that's different from there being a colorable basis of fact, but we think that still we would recommend no violation. This is where there is no colorable basis of fact at all. And so those are administratively dismissed by the staff. In the past, more than several years ago, they weren't even reported on. But I do want you to know these are cases for the public record that we have administratively dismissed after receiving a complaint or opening it ourselves. And I can go through each one, but I think we agreed 2 meetings ago that I would just give you a written summary or tell you that we've got them and be happy to entertain any questions. So I think in this case, all 3 of these are very plain cases. And I'm going to continue with my report, but if you want to come back to me with any questions, happy to take them at any time on this. And I will say also that, of course, any of those dismissals are without prejudice, so the case is already dismissed, but it can always be reopened at any time as long as we're within the statute of limitations.
Okay.
Let me next move, and I don't know that I'm strictly in this order of the agenda, but I don't know that it matters, to briefly mention our case counts and where we are in terms of resolving the so-called backlog, which for my purposes is resolved. Backlog, first of all, that would be the cases that we would have considered to have been inherited by commission staff 2.5 years ago when Robert and Bethany began working for the commission, and it was over 160 cases at that time. Right now, except for those cases that are in collection, and those collection cases are at the AG's office, it is effectively 0. There are a few cases that are service cases that I doubt we'll ever see service on, that we say we're still within our hands and could be formally closed, but we're taking that last sort of grasping breath to see if we can still do it, but I don't think that's going to happen. And we also, and I want to give Robert and Bethany a lot of credit for this. They've worked very hard with the AG's office to bring their caseload down too. So I want to comment on that as well. It's been a monumental job to get this tremendous number of old cases resolved, disposed of, reconciled in some way. Thank you very much. And we really want them gone. And frankly, as much as we can within bounds of our duties, we'd like to leave the past behind. But some things like late fees just haven't managed to escape. We have managed to get most of the cases down with the AG's office. I think they have 16 open now from 71 at one point, or 54 at one point, excuse me, 54. Of those 16 cases they still have open, 10 of them are on active repayment status. So there's only 6 cases that have really not been completely addressed or addressed to the point we think that they're resolvable with the AG's office. Our cases, except for those non-service cases, are, in my opinion, done. They're gone. And again, staff, I think, and not just Robert and Bethany, who've done a super job, but really staff have done a very good job over this last year. And we're just getting ready to talk about reviews, so we'll take that up. So that's where we are on that. A few other issues that I will touch on from our perspective. First of all, as I alluded to earlier, and it's really worth a lot of discussion, our space has been built out. The building out part's done. You've got furniture issues that still have to happen and a few filing issues that still have to happen with expanded space. We'd like to invite you all to come on up. And in fact, we will have some sort of housewarming activity when we actually get the furniture in the door. We're missing furniture and stuff. And I'm going to guess it's going to be another month-ish before that happens. Erwin is here. Our office manager has done a super job, though. And we're very happy with the space. We've got finally the room to expand, and that's great. And it really is, it's super. So the next thing is, let's talk about where we are on a variety of different audit issues. There are 2 audit issues that are going on with the state right now, and I don't think either one of them is in a situation where we think it's antagonistic, but still, to let you know. First of all, the Department of Office of Planning and Budget, we've been working through and with them on what they call a zero balanced budget audit. These are randomly selected from across the state and state agencies, and I can tell you that I think we've satisfied them with what we've given them. We've given them a lot. They actually asked for something yesterday they wanted by tomorrow. So that's the way it works, but that's okay. I am going to tell you without really any authority, and they haven't said this per se, but they've certainly hinted a lot, that they believe that we may actually need more resources for computers and maybe some staff resources. I don't have any idea, since I don't see that budget, where they're going to come down on various things. All I can say is that we've tried to be extraordinarily responsive to the requests. And frankly, I think if you were to talk to OPB about it, they'd tell you that given how their state agencies respond, we've been very, very responsive. And we really tried. Now, there was also an audit that had been requested several years ago by this agency, by the Department of Audits and Accounts. And as everybody knows, the 48-some problems that were found in that audit, we have tried to address. I think there's still other issues that they either didn't see or that we just don't have the basis to address. But they started doing a follow-up audit, and for whatever reason, they got busy with other stuff. They called me, today being Wednesday, I'll say Monday, to say, hey, we want to let you know we still haven't forgotten this, and we're going to do our follow-up audit beginning maybe in August or September. So they asked for your addresses to write you and let you know, and I told you who to contact, but you could send it to me and I'll make sure they get it, or I give you your business address. I haven't heard anything more from them, so we'll see. But I think we have good responses on pretty much everything that was in the prior audit. Not to say that, in my mind, that is a clean bill of health. I'll just be candid with you. I think there's a lot more that we can do to make this agency work better. And we're working on it, but some of that is legislative authority, some of it is financial, and some of it is just changing old practices. So I hope that as the next year, 2 years, we're going to work through that as well. Anyway, that's in a nutshell where we are right now. I think things are going pretty well. Our employee situation has been very stable, as you know, and we will be hiring 2 to 3 new employees that will be hired before the next meeting. We have space for them now, and we're going to put them in. Oh, let me ask, I'll make one other comment regarding the budget. I didn't comment on that, but just so you know. So, other than the 2% increase that was made by the governor for salary increases and related pension and benefits related to those increases, which are completely to be based on merit. And I've prepared a plan, given it to OPB, and I think it's essentially approved that they're purely merit increases this year. Our budget has stayed stable, and I don't expect it to go down. I will say that because we did not have the space to hire people, and we did not, unless we wanted to sit in the hallway, we couldn't spend everything in our budget. And so we've been underspending for 2 years now. Erwin and I crunched the numbers, Erwin mostly, and I will tell you that I think that this year we are going to give another $300,000 some dollars back to the state. And I'm glad to give money back to the taxpayers, but I can tell you we have use for that money when we can actually hire people, because that's money that's supposed to go for personnel that we haven't been able to bring in. And when we do, we'll do it. I also think we try to do an efficient job and cut some expenses, but the reality is the big money is personnel expenses we couldn't spend. And OPB knows that, by the way. So anyway, thank you very much.
Thank you.
Thank you.
Thank you very much.
All right, anybody have any comments or questions for Mr. Ritter? Okay. Thank you for the report, Mr. Ritter. All right, Mr. Fuller, any update on the cases in the AG's office?
Thank you, Madam Chair. No real updates. I think the only thing that is still pending were the Occidental appeals, still the court appeals. We're still waiting on a decision on that. But otherwise, with all the other cases, they're in various stages of preparation to go to OSA, the ones that have been referred over on a probable cause finding. So preparing the paperwork and complaints to then go to OSA and then we might be back here on some other final agency review issues in the near future. So, but that's really it.
Any questions for Mr. Full? Okay, all right. All right, any comments from the public? Okay, seeing none then, we'll move that we adjourn at 1:57 today. All right, all those in favor? Aye. Okay, we stand adjourned. Thank you, everyone.